My lord, in item number one, my name has been shown as a respondent, my lord. In that case, my lord, while I was public prosecutor, my lord, additional public prosecutor, then perhaps I used to represent one police officer, my lord. Now I cannot, my lord. My learned friend will
TP name is otherwise shown.
yes,
TP name is shown. All right. When the item is taken, you remind me. I'll ask the registry to stock up your name.
I may not be available, my lord, some other matter.
No, you did not be here, Mr. Sharma. Just remind me. NK Kalita name has to be struck off, right?
My lord, the same matter, my lord. I'm for NJ Das, my lord. Even
You
our
are also not there.
yeah, not there, my lord. How our name came with Hullo, my lord.
So you wait. The item number one.
Okay.
Yeah. Appropriate bench, please. 39
Regard to item number 27, ma'am. Today I pray for some accommodation, ma'am. We have to reconstruct the brief, madam.
Mr. P.K. Munir, Learned Counsel for the petitioner, seeks accommodation in the matter to reconstruct the brief. Prayer is allowed. Relist after date.
If I may take it,
You are
we have to apply for certificate copy.
you apply. You apply for the certified copy.
After vacation, we will take some time.
May. Any
Obvious.
problem? May.
Deeply obvious. I think to mention item number 5.
Fine.
The matter may be at 2 p.m.
You wait. Let it reach, then we'll see. Yes. You wait for some time. Yes.
Yes. I'm not, I like to mention for 16 of a criminal division.
রূপক আবার check করে নেবো. I believe there is a senior bench. However, in case it is not there, then you give it to
I know.
I look আবার.
I'm paying for listing criminal petition.
Why all the listing matters have come? Is there not a senior bench? There is, right? Mentioned before appropriate bench.
May I please, your lordship? I would like to mention item number 2. Your lordship, the matter is infectious. Petitioner is dead.
Just okay.
I'm appearing on behalf of Mr. A.K. Das.
AK Das. Just wait for a second because the other side counsels are not here. It will be called only. You wait. Yes.
For education.
None appears for the petitioner on call. Mr. N.K. Kalita and Mr. N.J. Das, right? Learned counsels appearing and P.K. Das, learned counsels appearing for the petitioners. For the respondent submits that they have been. But have you informed your client why you first you say NK Kalita, huh? That he cannot represent the private respondent in view of his engagement in the state of Assam as he's Mr. Kalita is APP. But Mr. Counsel, don't you think they need to inform the respondent? There's nothing on record. you're right, that Mr. NJ, NI Das or NJ Das? NJ Das, Mr. NP Kalita and Mr. PK Das submit that due to personal difficulty, they shall not be able to appear in this matter any further. However, it appears that they have not contacted the client and has intimated the respondent as regards the said difficulty. Unless and until the respondent is informed and informed in order to make alternative arrangement for due representation before this court, comma, the prayer of the learned counsels for striking of their name from the cause list from the case cannot be entertained. List after 3 weeks on a date to be fixed by the registry. It is needless to be clarified that the aforesaid councils shall take necessary steps by the next date of listing. You inform by registered post Mark B Sharma, na? B Sharma APP, huh? So here petitioner has died. So it has become infractions. Heard Mr.
H. Bora.
H. Bora, learned counsel appearing on behalf of Mr. A.K. Das, learned counsel for the petitioner. Also heard B. Sharma, learned APP for the state respondent. And appears for the respondent number 2 on call. Mr. So-and-so, learned counsel for the petitioner, submits that during the pendency of the criminal revision criminal petition, comma, the petitioner has expired and hence the petition has become infructuous. In view of the aforesaid endorsement, the criminal petition stands dismissed on being infructuous.
Number 3.
None appears for the petitioner on call. Since the matter has been listed after 6/8/2018 for the first time today, relist the matter next week, continue on such and such date. However, if on that date also there is no representation on behalf of the petitioner, this court may consider appointing an amicus curiae to represent the petitioner in the matter. All right. Mark the presence of Mr. B. Sharma, APP, and Mr. V.A. V.A. Chaudhary for R2.
Pass over for the time being.
Ms. Counsel? He has some difficulty today, so we are fixing it after the vacation, after the Bihu holiday. Heard MS? Huh? R. Begum, learned counsel for the petitioner. Stop. Also heard Mr. R.H. Mishra, learned counsel for the sole respondent. Mr. Mishra seeks a short accommodation in the matter on the ground of personal difficulty. Prayer is not opposed. Relist on such date. Interim, if any, shall continue till the next date of listing.
Number 5.
Yes.
May I please?
What is this petition?
Lord, I'm the petitioner. My lord, this application has been filed in the 482 for quashing and to take the appropriate decision because both the courts below have committed irregularities in calculation of the delay period, because the complaint case was filed by the present petitioner under 138 of the Negotiable Instruments Acts. And the court below at page number 29, my lord, annexure 8, the trial court observed that the complaint case was filed 1 day delay. There is a
Page,
delay of
page?
1 day at page 29, my lord, annexure 8 of my petition. Last line,
Who is appearing for the respondent? Appearing for the respondent? Huh? Why? Tuesday.
Huh?
Tuesday.
Tuesday.
Tuesday. There is another matter fixed too. Tuesday.
to my part maybe.
Hear it together. This piecemeal manner will not do. Heard Mr.
AKJ.
A.K. Jain, learned counsel for the petitioner, also heard Mr. G. Boro, learned counsel appearing on behalf of A. D.J. Haloy, learned counsel for the respondent. Mr. So-and-so seeks a short accommodation as the conducting counsel, Mr. Haloy, is occupied in another matter before this court, before in another court, huh? So, relist Tuesday or Monday?
Monday.
Monday. Respondent, anyone? No. None appears for the petitioner on call. Yes.
Sorry, my lord. Lordship, the petitioner here, background of the case.
Please 1 second.
My lord,
Last order I am seeing.
yes.
So the copy was served before the principal judge family court.
Yes. And the
And an affidavit was filed and this court has already taken note of
yes, my
it. But today there is no appearance.
So on the last occasion also, none appeared for the respondent.
All right, what is this petition?
Lordship, the petitioner is a grade 4 railway employee. Now, he had a love affair with the respondent. That was in 2007 and 2008.
2000?
2008. So, my lord, then they got married as per Hindu customary rituals at Kamakya temple. Subsequently, lordship, it was discovered that the respondent had hidden her true religion, and by fraud she entered into the marriage. So then, my lord, they moved apart. Now there were no legal proceedings like before any of the courts. Then in 2017, lordship, she comes up before the principal judge praying for maintenance. And then, my lord, the petitioner here, he files a petition saying that, stating the background that this is the background, therefore this is not a valid marriage, this is a void marriage. Now, during the pendency of the petition, my lord, her petition, a compromise was arrived at and the petitioner already paid, my lord, 6 lakhs to her as maintenance.
So you are challenging what?
The second maintenance petition, now she claims for for a minor child. So the issue is in fact, the learned court below has already decreed the,
Mr. Sharma, avoid saying the term put below. Trial court.
yes, style code, I'm sorry, ma'am. Yes. So the learned,
Trial courts are not subordinate or below to the law court.
yes, ma'am.
Yes.
So in fact, then my lord, she came before the learned family court and claimed maintenance under 125 proceedings. During the pendency of the proceedings, my lord, before any final order, there was a mutual agreement between the parties, which my lord is at annexure 4, which starts from page 26. And a sum of rupees 6 lakhs was already paid to her.
So you are now seeking quashing of the complaint.
Second complaint, now she has come after the marriage was annulled mutually on the ground raised by the petitioner by the
Let
learned.
us first see the complaint.
Yes. The present complaint, lordship.
Yes, the
Yes.
complaint which you are seeking
Yes,
quashing.
yes, ma'am.
Because otherwise I'm not being able to appreciate the argument.
yes,
Let me first see.
The complaint starts from, lordship, come to page 10.
Yes.
That the petitioner first party is a citizen of India by birth and a resident of aforesaid locality. Next paragraph. That the petitioner begs to state that the petitioner and the opposite party are well known to each other since 5 years, and as a result of their such love and affection, they got married. The marriage was duly solemnized on 28/4/2008 at Kamakhya Temple, Guwahati, as per Hindu rites and customs, and since then the petitioner and opposite party are living together as husband and wife.
Yes.
That the petitioner first party most respectfully begs to state that after marriage, the petitioner first party used to stay with the opposite party as husband and wife in the rental house at Narikal Basti near Zoo Road, PS Gitanagar, Guwahati for about 6 months peacefully.
Yes.
That the petitioner first party begs to state that out of wedlock, one male child was born, namely Aman, on 9/2/2009 at MMC Hospital, Guwahati, and he is reading in class 4 at Nunmati Public School, Naringi. Next, that the petitioner first party begged to state that from the month of May 2008, the opposite party started to torture the petitioner by mentally and physically. That's all. That's what he stated. That the petitioner first party further begs to state that the petitioner first party with much hopes and aspirations had entered into the nuptial tie, but soon all hopes and aspirations of the petitioner first party sank into the abyss of despair and frustration because of the maladjustment in temperament between the parties. Whenever the petitioner first party asked about the intimate relationship with other girls, the opposite party always used filthy language against the petitioner first party. That the petitioner always tried her best efforts to maintain peace between them, but the respondent became violent and tried to inflict mental cruelty in every walk of life. That the petitioner first party begs to state that the opposite party, for reason best known to her, was quite reluctant to live and cohabit with the petitioner first party, and at last the petitioner first party, despite of her almost efforts, was unsuccessful to bring about peace in their domestic life, and surprisingly the opposite party treated the petitioner applicant with so cruelty. Thus, this has ultimately forced and compelled the petitioner to leave the house of the opposite party in the month of October 2008 for safety and security of life, determining to take shelter in her parental residence. That the petitioner first party most respectfully begs to state before your honor that the opposite party is a government service holder under railway department. Moreover, having a government job and having different source of income and landed property at Madras and Guwahati, has been living with handsome earning. That the petitioner first party has no source of income to afford all the expenses of schooling, dressing, tutorial fees, healthy food, etc. of her minor son, and the opposite party has not paid any maintenance to her minor son since birth. The opposite party has deliberately refused to accept the petitioner first party and has neglected to maintain her. That the petitioner applicant filed a petition before the Principal Judge, Family Court number 1, Guwahati Kamrup Metro, White FC criminal number 18 of 2017, and another case is filed by opposite party White FC case number 118 of 2018, where the petitioner is respondent and both cases are settled outside the court. And finally, case was disposed of in Lok Adalat on 8/9/2018. That the petitioner first party begs to state that the petitioner first party is passing her days facing severe financial hardship without proper clothes, etc. in her daily life along with her minor child. That the petitioner applicant's son urgently needs of money for his maintenance and education. Otherwise, the health and continuity of educational progress of petitioner applicant's son will be ruined. That all the relations made opposite party acquainted with the circumstances of the petitioner applicant's son and asked him to help applicant's son, but the opposite party neither sent money nor gave any positive assurance. It appears from conduct of opposite party that he is refusing, ignoring to perform his legal ability. The petitioner applicant has no scope of getting any maintenance from opposite party without interference of this honorable court. So, he has lordship clearly suppressed the fact that the marriage has already been annulled by the learned family court. And on top of it, my lord, she was settled with a sum of rupees 6
lakhs.
lakhs. Now, my humble submission here is
Where is that settlement?
page 26, lordship. It starts from page 26. Annexure 4.
Yes.
It's clearly written also that the petitioner here has filed for annulment of the marriage. Clause 3, lordship, it's clearly written that the first party will pay a sum of rupees 6 lakhs. So she has completely suppressed these facts.
Where is the Lok Adalat order?
Lordship. The order, lordship, of annulment. Yes, lordship, kindly come. Not the Lok Adalat, but the learned family court.
No,
But-
this case was withdrawn, right?
No, it was decreed with mutual consent, annulling the marriage. Lordship, kindly come to
Case
annexure.
number 18 of 2017.
No,
Correct. I want to know what 18 of 17.
yes, not that. It is 111 of
First,
2000.
show me the order of.
Yes,
18,
yes.
20.
Lordship, annexure 8 at page 40. That is the order of the learned family court.
Yes, please read.
Page 40, lordship.
Yes, please.
May I read it?
Yes, please.
Both the parties are present. The respondent has filed one petition bearing number 362 of 19, stating that she has no objection in granting the decree of nullity.
This is FC Civil 111 of 18.
Yes, my lord.
No, the other one.
That is my petition. That is the one I filed for annulling the marriage.
No, what about FC criminal case number 18 of 2017? Where is that? That is the maintenance case filed by her.
Yes. Lordship, page,
Yes, that is
annexure
at
6 at
38.
page 38.
38. Yes. Okay. Now 40. Read 40.
Yes. So the, on the strength of the agreement between us, Lordship, the case was withdrawn because she consented. She was paid a sum
Please
of,
read,
Lordship.
please read 7 to 19, page 40.
Page 40, yes. Yes. Both the parties are present. The respondent has filed one petition bearing number 362 of 19, stating that she has no objection in granting the decree of nullity as prayed for by the petitioner. Heard both parties, perused the case records. This case is arisen out of an application filed by the petitioner Sri Duryodhan under section 12C of the Hindu Marriage Act against the respondent Srimati Majoni Khatun alias Majoni Das, praying for annulment of marriage between the parties. After receiving the notice, the respondent appeared before the court. Thereafter, the case was referred to the learned counselor for conciliation but failed. After going through the case records and hearing the submission of both sides, it is found that the marriage between the parties was solemnized on 28/4/2008 at Guwahati in Kamakhya temple as per Hindu rites and customs. But there has been no relationship between the parties since 2008, as the respondent has severed relation with him by concealing her real identity, which is relevant. Her real identity has induced the petitioner to enter into the marriage by misrepresentation and fraud, and thereby has broken the trust of the petitioner and has shattered and shaken the foundation of their marriage, and as such, their marriage is liable to be declared as null and void. The marriage has not been consummated since the date of marriage. Hence, he filed this case seeking annulment of their marriage by a decree of nullity. During the pendency of the case, the respondent, by filing the instant petition, has stated that both the parties mutually settled all the disputes between them outside the court, and has no objection in passing a decree of nullity by declaring their marriage as null and void as prayed for, and hence she gave her consent for annulment of marriage between them. Therefore, as per prayer of the parties, the petition filed by the petitioner is allowed on consent by passing a decree of nullity. Prepare a decree accordingly. Copy of order be furnished to the petitioner free of cost. Next page of Lordship is a type copy of the decree. Is the decree, my Lordship? A
When
petition,
was the second complaint filed? What is the date?
second complaint, Lordship. I'm coming to it.
The second complaint is 660 of 19.
Yes, my lord. 660 of 90. So
Okay.
notices were issued by the
Yes, I've seen.
learned court on
November
8th day of
19.
November.
You don't have the original copy of the complaint.
No, Lordship, this is what was served and I have annexed it, my lord.
Well, this is not a signed copy, and plus it is signed, but the date is not here. Okay.
Hard case, Lordship. Already I have paid, which is otherwise not entitled to under the law. That 6 lakhs which I paid, my lord, she is not entitled because the marriage was annulled. So it is not, it is a void marriage. And she now come with a second complaint. And in any case, Lordship, if the compensation paid to her, that has to also include whoever is dependent on her. That has to include whoever is dependent on her, my lord. And see the nature of the fraud, Lord, what is happening. And my lord, I'm a grateful employee and I've been out of my own conscience, I paid the first time.
Right. Heard Mr. A. Sharma, learned counsel for the petitioner. None appears for the respondent on call. matter is taken up for the matter is taken up for final disposal. This is an application under section 482 of CRPC 1973 for setting aside and quashing the complaint in FC Criminal 660 of 2019 under section 125 of the CRPC. Stop. The brief facts of the case is that the respondent filed a complaint dated nil alleging inter alia that the respondent was married to the petitioner on 28/4/2008 as per Hindu rites and customs, and accordingly thereafter they lived as husband and wife. However, later the petitioner started torturing her both mentally as well as physically, for which she had to leave the house of the husband of the petitioner and took shelter in her parental residence. Accordingly, the instant petition has been filed under section 125 Criminal Procedure CRPC 1973 for maintenance for grant of maintenance to her. So, the said case was registered as FC Criminal Case number 660/2019. The family court by notice under the family court thereafter issued notice to the petitioner directing
My lord, this petition was filed for maintenance for her son, which is 660.
in between you write that it is further alleged that out of the wedlock, one male child was born, namely Aman, on 9/2/2009. Then you start the torturing before torture. Accordingly, the application has been filed for maintenance accordingly. We file accordingly the respondent wife filed the application on behalf of her son under section 125 CRPC so and so for maintenance to the son. Stop. Mr. Sharma, Learned Counsel for the that, and then I have already said that it was registered and notice issued. That part will come after this. Okay. You got it? I'll edit it, but Mr. Sharma, Learned Counsel for the petitioner submits that the instant case but Mr. Sharma, just one thing. This is not a complaint. This is an application under section 125.
Yes, By way of a complaint, it's fine.
No, but can this be quashed like
But
this?
yes, because it is under the erstwhile CRPC, 125 CRPC.
No, but it's an application.
Yes, my
You
lord.
can always take these issues before that court. It is not a case where summons and warrants with arrest of warrants are going to be arrested. You see, the power of quashing has
Lordship,
to be exercised sparingly,
Lordship,
isn't it? Generally, FIR and complaint one can understand.
Lordship.
Now, in certain situations, orders and all also issue of process.
Yes.
But here is a case, though it is it is under the criminal code, but
Lordship.
essentially it is a case of maintenance,
It's a case of maintenance.
isn't it? Then how is this petition for quashing that is maintainable?
Because subsequently, Lordship, under those provisions, the court has the power to issue warrants, maybe
But that stage has not come.
not come. But then it is a
I am not convinced. I have a feeling this is not maintainable. So what has happened to that maintenance case? Is you have obtained a stay order?
no stay as such.
Then what has happened? What is the status?
No, that, my lord, there were, in between, there was an order of stay for a long period of time.
That's right. So that means you have obtained stay also.
That was there, but it
Mr.
was,
Sharma, you have to convince this court. I was taking it for disposal, but I'll keep it next week.
Lordship.
You
Let it
come.
be after the vacation.
No, you come after you are getting the weekend. You do your homework.
Well,
You have
Yes.
to convince this court as regards the power to quash this application under 125.
125.
Whether it
Understood.
can be done or I
Yes.
have a reservation because strictly speaking, you see, this is not a criminal proceeding.
Basically, yes, my.
It is not a criminal
Yes.
proceeding. You can always appear. So why are you not appearing? Instead of that, you have straight away come before this court, obtain stay. The entire proceeding is under stay. You can always appear before the court, family court, and submit all this. You can exhibit the compromise deed, the fact that you have already paid 6 lakhs as per that compromise.
Lordship.
You can always do that.
Lordship, let it be fixed next week. I'll satisfy my lord that whether this
You
power court has
delete
the
this whole
power.
thing. Heard Mr. A. Sharma, learned counsel for the petitioner, none appears for the respondent on call. It appears that by filing this application under section 482 of CRPC 1973, the petitioner is seeking setting aside and quashing the complaint in FC Criminal 660/2019 under section 125 of the CRPC. Stop. This court has reservation as regards the application filed under section 125 of CRPC being called a complaint and the powers of this court under and as regards the powers to quash such application filed under section 125 CRPC seeking maintenance. Mr. Sharma, so and so seeks accommodation to assess to submit in this regard. Prayer is allowed next week and small matter, you just show.
Lordship.
I have my doubts.
Lordship.
Otherwise, you withdraw and you contest. Mr. Sharma,
Obliged.
what do you say? 125 application can be called complaint. And 125 application, of course, it appears this 125 application has been filed, could be, to harass. We don't know. But nonetheless, it's a right under, isn't it? And
Yeah.
first time the wife had come. This time she's for the son. Now the court will adjudicate. Why should this court an application like this? Correct.
Next,
You think over.
Yes, yes. Applies.
Seven, who's appearing? None appears for the petitioner on call. Ms. Barua? This is a very old revision petition. Though some names have been shown for the petitioner, but no one is appearing. This petition is against the conviction. Would you like to assist the court on behalf of the petitioner as an amicus? Please wait. None appears for so and so. Also heard Mr. B. Sharma, at APP for the state respondent. Since this revision petition is TCR Ahisa. Thanks, sir. It appears that, not since, it appears that the trial court's records have been received. Stop. It appears that the revision petition pertains to the year 2013. However, today when called, despite the names of 4 counsel, right? Names of 4 learned counsels appearing in the reflecting in the cause list on behalf of the petitioner, there is no representation. In view of the same, this court deems appropriate to appoint MS P. Barua. I'll give the full name, Padmini. Padmini Barua, Barua. Okay, got it? As an amicus curiae, first you say requested so and so to assist this court as an amicus curiae on behalf of the petitioner, which she readily accepted. Accordingly, so and so is appointed as an amicus curiae to represent the petitioner in this revision petition. Let registry furnish copies of the revision petition along with photocopies of the case records to MS so and so learned amicus curiae. After Bihu, the date list on such and such date for hearing. And let me admit it also, because though records have been called, but there is no formal order of admission. You say admit, and any respondent is there, Mr. Sharma, have you seen? Okay. Admit, since respondent is represented, no formal notice, huh? And then hearing. And let registry reflect the name of MSP Borwa, let amicus curiae in the cause list appearing for the petition.
Yes, please, Your Excellency. As per office note dated 29/3/25, service about the respondent number 2 await. It awaited.
It's a old matter.
Yes, very old matter, my lord.
Who is R2?
To my lord informant. Informant.
Can we appoint an amicus or a legal aid counsel? Because it's a matter of 2017. Also, it has not been done.
That was rectified, my lord, later.
Fresh steps.
My lord, I have already 2 times I have taken steps.
No, but then it's a criminal appeal. Petition.
My
My lord, matter may be fixed for hearing.
You cannot fix it like that for hearing when the service reports indicates that it is not
It
complete.
was from police station, my lord, it was given.
It was issued through police station.
Yes, from police station, it was last time.
So then you call for a report because it says no service report in respect of R2 has been received back from the OC Kokrajhar police station. So you call for a report. Office note dated 29/3/2025 indicates that no service report in respect of the respondent number 2 has been received back from the OC Kokrajhar police station till date. Mr. So-and-so, B. Sharma, Leonard APP for the state, takes 1 week time to obtain instruction in this report, in this regard, and place the report before this court on the next date of listing. Prayer is allowed after 1 week.
I will furnish.
Yes. Let a copy of the petition be also furnished to Mr. So-and-so by Mr.
I Talukdar.
I.A. Talukdar and counsel for the petitioner.
Let the matter be fixed for my lord.
After 3 weeks or date.
Okay.
Yes. Just 1 second, Mr. Talukdar. Mr. Sharma, 14 May is too long and it is from Kokrajhar. You just have to obtain the report. Suppose it has already been done. Then this court can fix the matter thereafter for hearing. So you just have to obtain that instruction. No, that is why then again this court has to give some direction. So now keeping it till it will further delay. That's why I thought let us have it after the opening. All right. 2 weeks or date. I got date here. It is me. Here also await service. Yes. I think since it has not come for, but there is no representation on behalf of. None appears for the petitioner on call. Office note dated 29/3/2025 indicates that neither AD card nor any unserved notice in respect of the respondent number 2 has been received back by the section till date, upon whom notice was issued on 13/7/2018. This can be deemed service and we can appoint a legal aid for R2. It further appears that despite notices have been issued more than once, the same has not been, the same could not be, comma, not the same. AD cards of the same has been received back. Be that as it may, Mr. Gautam, do you like to assist the court on behalf of the respondent number 2?
I'd be honored.
Requested Mr. N. Gautam, learned counsel, to represent R2 as an amicus curiae, which he has readily agreed. Accordingly, Mr. N. Gautam, learned counsel, is appointed as an amicus curiae to represent the respondent number 2. Is the matter ready for hearing? Let registry furnish copies of the petition to Mr. N. Gautam, learned amicus curiae. Kiba aise nahi? You have a look at, I'm not fixing it for hearing right away. On the next occasion, we will see. It is also it is needless to be clarified that on the next occasion, in the event there is no representation on behalf of the petitioner, this court shall consider appointing an amicus curiae to represent the petitioner in this criminal petition. Relist, yes. End of April, Vidya. Let registry reflect the name of Mr. N. Gautam, learned counsel, learned amicus curiae in the cause list for the respondent. Number 2.
Item number 10. Lordship, as per the court order dated 22/1/20, it was taken fresh steps. For the office note to find out the reflective that neither any card or answer notice except the district paid by the same.
Yes. That was in 2020. You want to take fresh steps?
Step was taken by lot of 4/3/20. Court order is dated by lot 22/1/20.
A fresh notice issued upon so and so has been received back unserved with postal remarks, insufficient address.
Yes.
Then again, it was directed fresh steps.
Yes.
Then notice has been issued upon the so and so by so and so. After that, it has not come back. I think you try. Mr.
F.A. Hassan.
Mr. So,
F.A. Hassan on behalf of SCB.
F.A. Hassan,
Yes.
learned counsel for the petitioner seeks submits that fresh steps in respect of R2 may be allowed to be taken, as the office note dated 4/3/2020 indicates that neither AD card nor any unserved notice in respect of R2 has been received back by the section till date. Prayer is allowed. Relist after 3 weeks on a date to be fixed by the registry.
Right.
Take fresh steps.
Yes.
None appears for the petitioner on call. It appears that here the unserved notice has come, but it has been served on one cartoon, someone called, but the relationship is not mentioned. That will not do. Anyway, since there is no representation, released after 3 weeks on a date to be fixed by the registry.
No, but well, to say Lordship, regarding the item number 10, there is the interim order.
In item 10, interim if any shall continue to the next day of the next.
Alright.
Yes.
May I please, Lordship? Lordship, I got information from my client that final report has been filed in this case, Lordship. If this thing can be verified by the prosecution, Lordship,
Your name,
B. Chakma Lordship.
Mr. B. Chagma.
Chakma Lordship.
Chakma Learned Counsel for the petitioner submits that that he has received instructions to the effect that FR has been submitted in the criminal in the case in hand. In the case, stop. Mr. B. Sharma, APP for the state, accordingly seeks 1 week accommodation, 1 week's time to obtain instruction in this regard. Let the matter be listed again on, yes. All right, let us have the report on such and such date, DDPO after view, to enable Mr. B. Sharma, APP for the state to submit, to place a report from the jurisdictional police station as regards the status of the criminal case. Status of the criminal case.
Lordship, Lordship, there is also earlier date, Lordship. 2 CD was called for, Lordship, in this case. 2 CD was called for, Lordship.
All right, dude.
Only applied.
Submit a case diary. Status report along with case diary. None appears for the petitioner on call. Interim order passed earlier is accordingly shall remain shall remain discontinued. Relist after 3 weeks on a date to be fixed by the registrar.
For hearing, item number 14.
Third to the matter of substantial last and Lordship, I believe that Mr. Burua was.
I'm reserving it. Mr. Borwa is not here. To reserve for judgment. This is that sewage.
Sewage.
Only one thing, the word domestic effluent, is it defined anywhere?
Also, we'll take up for a matter of some and for second.
I just want to know that, huh? 20%.
And 16.
Yes,
Lordship was.
finance,
It comes for view, Your Lordship.
huh?
It comes for view in that.
Heard Mr. R. Singhal, Learned Counsel appearing for the petitioners, none appears for the finance department on call. I'll release this from part heard. Matter stands released from part heard,
Otherwise, Your Lordship.
going on
As a
from a long
last
time.
chance, Your Lordship, on 25th, Your Lordship.
Relist on
25th, Your Lordship.
25, so and so, it is needless to be clarified that on the next date of listing, even if there is no representation from either side, the matter shall the matter shall be released from part heard.
Item number 20.
Yes.
My lord, this, originally, my lord, the Chief Judicial Magistrate Bongaigaon, my lord.
Just 1 second. Yes.
my lord, the trial court, the Chief Judicial Magistrate Bongaigaon, my lord, uh, uh, convicted the petitioner, my lord, under section 325 and under section 341, my lord. In under 341, my lord, he was imprisoned for 1 month, my lord. Under section 341, he was imprisoned for 1 month, my lord. And under section 320.
1 second. Mr. Borwa, that you must have come for that Parthard matter. I am reserving it for judgment. Okay. Only thing, Mr. Gautam was there at that time. I wanted to know if the word domestic effluent is defined in any of the statutes. See, because why I'm asking this, the object, in the object, it is mentioned that this, why the Water Act was brought. Because a lot of sewage goes to the streams, rivers from both domestic as well as, correct. Now that was the object. Now, if that is the object, then perhaps, so that is something going on. So in case you get something, because apart from the definition of sewage, there is nowhere the word. That too I have seen, but domestic otherwise is not defined. In case you get something by Monday, Tuesday, you are at liberty to give it to the court master. But whatever is given, please give a copy as well as to Mr. Gautam. Huh? He may come back. He said he will check and come back. So about as regards domestic effluent. So if he gives something, I will.
Before I start, my lord, there are, my lord, two petitioners, my lord. One is Sarita Bala, Sarothi Bala Bormon and Onita Bormon. Mother and my lord, the daughter, my lord. The mother, my lord, petitioner number 1, my lord, died.
Sierra Rahisen, right?
My lord, petitioner number 1, my lord, died, my lord, on 23/12/2024, my lord. I have the death certificate.
Petitioner number 2 died on
1, my lord. Petition number 1, my lord. Sarita Bala Bormon, wife of Rameshwar Bormon,
she died when?
23/12/2024.
23/12/24.
2024.
24. Expired.
Only
Okay.
petition number 2 is, my lord, there.
So it will continue as far as petition number 2 is concerned.
My lord, the trial court, my lord, learned Chief Judicial Magistrate Bongaigaon, my lord, convicted the petitioners, my lord, under section 341 and punished for 1 month, my lord, simply imprisoned for 1 month. And under section 325, my lord, punishment is for 1 year, my lord. My lord, I annex the judgment of the learned Chief Judicial Magistrate, my lord, at page 21.
Just 1 second. Sorry, I am interfering you
No,
every
no.
time. Mr. Chaudhary, you've come for that matter. Anything on domestic effluent?
My lord, if it is not inconvenient, I'll also apply my mind to it. Could it come on Monday?
All right, I can do that. Can Mr. Gautam, Mr. Borwa had just left. Can you call him? Because otherwise, I thought I'll reserve it and giving a liberty to both sides. But if you want, I can also keep it for Monday. No problem.
Monday, my lord. Regarding that domestic effluent, my lord, if I find
If
some
it is
material-
defined, because you see, Mr. Chaudhary, let me say, let me reveal what is in my mind. The object, that if you read the statements and objects in that Water Act, you will find it talks about domestic as well. The word is there, but nowhere I find domestic effluent is otherwise defined. Now, because why I'm saying all that will have some meaning, because if I have to interpret that term in your favor, then I have to be conscious whether it is in tune with the object or not. It cannot go contrary to the object because these are statutory interpretation, correct? This is something that is also there in my
In
mind.
that case, my lord, to give full assistance, let it come up on Monday, my lord.
Alright.
I'll try to find out
Alright.
what is the legal connotation of domestic effluent.
If in case, and you read that
I'll find out.
statement and object.
Yes.
Because otherwise, I was thinking of applying ejusdem generis, but then there are limitation also.
Right.
Isn't it?
Anyway, I'll find out.
এইটো CAV করব নালাগে relist anything
So on Monday, my lord. Yes.
relist on Monday, huh? That's fine. Please inform Mr. Borwa, huh?
Yes.
Uh,
My junior has informed he's on lakes in some other.
no problem, just inform him that we are
Regarding
keeping it
Monday.
on Monday. Yes.
When the London Chief Judicial Magistrate, my lord, first, my lord, convicted the petitioners under section 341 and punishment is for 1 month, my lord. And under section 325 for 1 year, my lord. Later on, my lord, on appeal, my lord, the additional session judge FTC Bongaigaon, my lord, acquitted the
Where is the appellate court's order?
appellate order at page 30, my lord.
Yes, let's
And
read.
it's a three. Date of judgment is on 38/2012. May I read, my lord? This criminal appeal is directed under section 374 of CRPC against the judgment and order passed by the learned Chief Judicial Magistrate Bongaigaon in GR case number 491/2009, dated 27/2011. By that judgment and order, learned trial court has convicted the accused appellant under section 341 and 324/34. My lord, this is not there, my lord. 34, I was not convicted under 34. 34 is not there, my lord, altogether. And sentence them to undergo SI for 1 under section 341 IPC and SI for 1 year and a fine of rupees 500 under section 325 IPC in default SI for 1 month. Being highly aggrieved by their judgment and order, the appellants have preferred this appeal on the following ground. Ground number 1, that the injured complainant lodged the ejahat at the instigation of other person as a cross case, as the husband of the appellant number 1 lodged an ejahat against the complainant, which has been registered as Bongaigaon PS case number 362/2009, corresponding to GR case number 490/09. Number 2, that the injured failed to disclose the incident as narrated in her examination in chief in her ejahat. Number 3, that there was delay of 3 days of filing of ejahat. There was no explanation for delay in the ejahat. So the delay without explanation is fatal to the prosecution case. And my lord, in cross case, they were acquitted, my lord, only on the point of delay, my lord, of filing ejahat, my lord. I have annexed that judgment also. That the prosecution has failed to examine the radiologist to prove the alleged injury of fracture sustained in the injured. Number 5, that the PWs are not reliable and trustworthy as they fail to support their statement made during investigation of the case. That the number 6, that the learned trial court failed to appreciate the evidence in proper perspective and hence failed to set aside and impugn judgment and order. My lord, now, my lord, the learned trial court, my lord, appellate court discuss it from my lord, para 6, my lord. Exhibit
Yes.
1 is the ejahat filed by the complainant on 11/9/2009 at North Bongaigaon PP. It was alleged that on 10/9/2009 at about 10 AM, the complainant was assaulted by Sarathi Bormon with a lathi on village road, causing injury on her left hand and forehead. She gave complaint between the villagers. As at about 6 PM on the same date, accused person criminally trespassed into her house and assaulted her and her daughter with lathi, causing serious injuries on their person, for which her left hand was broken and suffered injuries on her forehead. Her daughter also got injuries in her finger. Police registered a case as Bongaigaon PS case number 383/09. My lord, it should be 363/09, my lord, under section 341, 447, 325, 4506 IPC. And on completion of the investigation, submitted charge sheet against the accused appellants under section 341, 323, 506 IPC. During trial, charge under section 341, 325, 506, 34 IPC were framed and read over to the accused appellant. Prosecution has examined altogether 6 witnesses in this case. Accused were examined under section 313 CRPC. Defense declined to adduce evidence. After hearing the argument and after appreciating the evidence on record, learned trial court has convicted the accused person under section 341,
Not 506.
section 341 IPC prescribe punishment for wrongful confinement. Section 340 IPC define what is wrongful confinement. It reads as whoever wrongfully restrains any person in such a manner as to prevent that person from proceedings beyond certain circumscribing limits is said wrongfully to confine that person. The section require 2 essential: wrongfully restraint of a person. Number 2, such restraint must prevent that person from proceeding beyond certain circumscribing limits. The evidence of PW1 injured shows that on the date of occurrence at 4 p.m., both the accused persons entered into her house and assaulted her and her daughter. PW2 deposed that the occurrence took place in the house of the victim. Both PW3 and PW4 also stated that the occurrence took place inside the house of the injured. Here, there is no any iota of evidence that the informant were restrained by the accused person. So, question of attracting section 341 IPC does not arise in this case. I fail to understand as to why learned court below has convicted the accused person under section 341 IPC, in spite of having no evidence on record.
The 341 appellate court has
Acquitted man.
acquitted. But ultimately uphold the conviction against 325.
325, it's a minor modified from 1 year to minor 6 months. Minor 12, my lord, the discussion, my lord, regarding my lord evidence. PW1, the injured has stated in her
1 second. Yes. 325. Grievous hurt. Yes.
No, my lord, section 325 IPC prescribe punishment for voluntarily causing grievous hurt. Section 320 IPC defines that what is grievous hurt. It reads as the following kinds of hurt only that designated as grievous. First, emasculation. Secondly, permanent privation of the sight of either eye. Thirdly, permanent privation of the hurting of either ear. Fourthly, provision of any member or joint. Fifthly, description of or permanent impairing of the powers of any member or joint. Sixthly, permanent disfiguration of the head or face. Seventhly, fracture or dislocation of bone or tooth, my lord. Under this, my lord, category, I was, my lord, convicted. Eighthly, any hurt which endangers life.
Under 7.
7. Now, my lord, at para 12, PW1, the injured has stated in her evidence that as a result of the assault, her left hand has got fractured. During his evidence, PW2, an eyewitness deposed that it was dark, my lord, at the time of incident. He saw the incident, but he did not know who assaulted whom and what was the weapon of assault. PW3, another eyewitness, has reported that he went to the place of occurrence after hearing noise and saw that both the accused persons assaulted the victim with lathi, for which the victim's hand was broken. PW4 went to the place of occurrence after the incident and saw the victim with injuries lying on the floor and accused were returning from the place of occurrence. Regarding, my lord, PW2 and 3, my lord, These are the, my lord, improvement, because they have not stated in 161, my lord. The statement recorded before the court was not, my lord,
But
corroborated.
you realize you are before a revisional court. Jurisdiction of the revisional court is limited. So you have to show what is the error in law committed. Then only this court will go into the evidence.
Well, 13 para, the evidence thus discloses that the victim suffered injuries as a result of assault made by the accused person. Her left hand was broken, so far injuries of the victim is concerned. It is well proved by the prosecution in this case. PW5 is the medical officer, and according to him, he detected in fracture on left ulna on the basis of X-ray report on the person of the
Fracture on
victim.
left ulna means
Ulna,
anyway.
he has opined that the injury was grievous and caused by blunt explosion. The Azahar, as well as the evidence on record, disclosed that the accused used lathi for causing the injury. Lathi is definitely a blunt weapon. It means the victim got previous injury caused by blunt weapon.
And as per 325, evidence is there. Even if two views are possible, this court shall not intervene.
Find that there is other point, my lord.
No, but this evidence are there on the basis of which the appellate court has firmed the conviction under 325. Nothing, this doesn't appear on the, you see, because this court is now not going to weigh this evidence. Correct.
I thought-
This court this court has to see, number one, if there is any legal evidence or not.
That is,
Correct?
yes,
It appears there is evidence.
my lord,
Now, whether these evidence are sufficient, not sufficient, that aspect, this court will not go now. The trial court and the appellate court has looked into these evidences. This is not, but however, you show that no, the evidence on the basis of which the courts have acted upon is inadmissible evidence.
that
or-
is there.
You see, you have to show that it is inadmissible. Merely raising a suspicion will not do. That 161 not said. Here it is said. That will not make the testimony of these witnesses as inadmissible in law. Isn't it? There is nothing like this because 161 is not the substantive piece. It is in the court. That raises a doubt. You see, that is why I'm saying.
And
You understand? Because two courts have given concurrent findings.
yes,
And this court is now exercising revisional jurisdiction. You have to address to that effect and show that no, this evidence on which basis the appellate court has affirmed is absolutely no legal admission, cannot be evidence in law. For that, you have to show me from the statute. Isn't it? Number one. Number two, that there was no evidence. If evidence inadmissible or no evidence, or the appellate court has acted contrary to the law. Let's go to the trial court now.
Yes.
I have read this. Let's see the trial court judgment.
trial court judgment.
Yes, you can start where the evidences are discussed because appellate court has referred, but has not laid out in detail. So you can start from paragraph 7, page 23 of the paragraph number. One second. Which page was it?
At case 26.
Yes, please. Now, this is part of which? This is the part of the trial court.
Page my lord 33 is
Mr.
the
Sharma,
appellate.
you want this court to go into the trial court judgment?
at page 33. Para 14.
All right, all right, all right. No problem. Para? Yes. I have read it actually. That's why, anyway, but you read para
14.
para 13 or 14? 13. Okay. All right, read.
PW5 is the medical officer and according to him, he detected fracture on.
We've read it. Yes, read. These are two views the view has taken. Mr. Sharma, why are you short circuiting the arguments of the petitioner counsel? Let him finish. Let him finish. I'll hear you. Yes. Trial court.
Trial court judgment is at page 21, my lord. Next slide, please.
21.
Page 21.
Yes.
Judgment delivered on 27, 2011.
All right. We can skip the first few paragraphs. You come to paragraph 7.
Para 7, my lord, at page
Yes.
23, my lord.
Yes. Evidences are discussed from there.
Yes.
So start from there.
PW1 is Srimati Drupadi Borman, who is the informant of injured person in this case. She has stated in her testimony that the occurrence took place about 1 year back at 7 o'clock. In my FIR, my lord, in FIR as well as in the, my lord, evidence, my lord, there is no incident regarding 7 o'clock, my lord.
Correct. You read.
Before the aforesaid occurrence, on previous night at 1:30 a.m., one Rameshwar called her, but she did not open the door. Thereafter, he told her that he would take revenge. On the following day at 4 o'clock, two accused persons entered into her house and assaulted her. As a result, her hand was broken. They also assaulted her 7-year-old daughter. As a result, her finger was broken. Her daughter died in last Kali Puja. On the following day, she lost Azahar. Exhibit 1 is the Azahar and Exhibit 1:1 is her signature. She has admitted in her cross-examination that the accused person also brought a case against her and the same is being tried and that she was assaulted with wooden lathi. She was further stated in her cross-examination that in the north of her house, there is a house of Kamabala. In the south, there is a house of Rameshwar Burman. In the east, is a house of Lal Mohan Burman. And in the west, there is no house. She has also admitted that the accused Saruthi, her sister, and accused Onita is her niece. PW2 is Rothin Burman, who is the co-villager. The occurrence took place in the month of Bhadra at 6 p.m. Hearing shouting, he came to the place of occurrence and found there was a scuffle in the house of Drupadi Burman marked as PW1. PW3, Sri Ugal Burman, who has stated in his testimony that the occurrence took place about 2 years back at 6 to 6:30 p.m. Hearing halla, he came to the place of occurrence and found the accused person entering in the house of the informant and assaulted her with bamboo lathi. As a result, her hand was broken. He has stated in his cross-examination that the house of the informant is adjacent to the house of the accused person and that the accused also brought a case against the informant regarding the occurrence in question. He has further stated in his cross-examination that the accused Saruthi is the elder sister of the informant and accused Onita is the niece of the informant. PW4 is Sri Pakilal Burman, who has stated in his testimony that the occurrence took place about 6 p.m. and hearing Halla, he came to the place of occurrence and found the informant lying on the ground and the accused person running towards their house. He found injuries on the hand of the informant and on the finger of her daughter. In the cross-examination, he has stated that his house is nearby the house of the informant and that he came to the place of occurrence after the occurrence. Para 11,
You have a very weak case.
my lord, I'll submit, my lord, there are so many points, my lord.
Yes.
My lord, 313 was not, my lord, taken, it is, my lord, defaulter 313, my lord.
But you have not adduced evidence. 313 is your explanation. That is not substantial piece of evidence.
My lord, the learned court has put me in my defense also, my lord, that I will show, my lord, your lordship. And there is a judgment of Rina Hazarika, my lord, of the
So
honorable.
you are right. If the incriminating circumstances is not
Not
put
put
to you in 313, certainly you will have a case.
That is,
That you can show.
and my lord,
But,
sexual, my lord,
But that is, you see, even the gist is sufficient.
this, no, the, my lord, the PW3's statement was not put to me, my.
PW3 statement was not put to you
Yes,
because PW3 is the eyewitness,
yes, man, this is the, my lord,
not put.
yes,
Where is the 313 statement?
one, I have the copy also.
I'll go to records. Just, Mr. Sharma, please find out the 313 and see whether the statement of evidence of PW3 was put or not. To the effect that he said he found the accused person entering and assaulting her with bamboo lathi. As a result, her hand was broken. This part which PW3 have said is put or not put because the petitioner claims it was not put in 313. Have a look.
And my
I'm
lord,
waiting. Have a look.
section 4 and section.
You read. 313. You read.
My lord, the PW3, my lord,
313.
313. What's the, my lord, PW1 এ সাক্ষ্য দিছে যে আপুনি অন্য পদকীয় লগত মিলি আহিনে 5টা মান বজাত মোৰ ঘৰত মাৰপিট কৰে তাইক আৰু তাইৰ ছোৱালীৰ ঘৰত তাইৰ বাওঁ হাত ভাঙে আৰু ছোৱালীৰ আঙুলি ভাঙে আপুনি কি কয় মিছা
This
প্ৰশ্ন
is
নম্বৰ 2
PW1.
প্ৰশ্ন নম্বৰ 2 PW2 এ সাক্ষ্য দিছে যে আপুনি অন্য পদকীয়ৰ লগত মিলি গোচৰীৰ ঘৰত সোমাই তাইক বাঁহৰ লাঠি দি মাৰপিট কৰে ফলত হাত ভাঙে আপুনি কি কয় মিছা প্ৰশ্ন নম্বৰ 5 নেক্সট 5 আপুনি আপোনাৰ পক্ষে সাক্ষী দিবনে নিদিয়ে নেক্সট মানে প্ৰশ্ন নম্বৰ 3 PW4 এ সাক্ষ্য দিছে যে তেওঁ আপোনালোকৰ অন্য পদকীয় গোচৰীৰ ঘৰত পৰা নিজে ঘৰৰ দৌৰি যোৱা দেখা পায় আপুনি কি কয় উত্তৰ মিছা প্ৰশ্ন নম্বৰ 5 PW5 এ সাক্ষ্য দিছে যে তেওঁ গোচৰীয়া গণক পৰীক্ষা কৰি তেওঁৰ গাত টেণ্ডাৰনেছ আৰু ফ্ৰেকচাৰ অফ লেফ্ট উলনা বন পাইছে আপুনি কি কয় মিছা That much.
What about 3? So it appears that the other evidences, PW2, 4 have also said that they have seen her being assaulted.
PW4 might not state that we saw that they are fleeing from the place.
Correct. And 2 also said we came and found there was a scuffle.
Specific is that might not PW.
PW3 is specific. He's right to that effect. Anyway, let's continue. Then will it not become fatal? No, 3 is specific. 3 has specifically said he found the accused person entering in the house of the informant and assaulted her with bamboo lathi. As a result, her hand was broken. But PW2 says he came to the PO and found there was a scuffle in the house of Swens. PW4 says, hearing Halla, he came to PO and found the informant lying on the ground and the accused person running towards their house. PW5 said, PW5 is the medical officer, 6 is the IO. That is, you see, I'm not on that. Here, you see, 313 is a very important examination. Correct? Because it is an opportunity given to the accused person where he has he gets an opportunity to explain and rebut the incriminating circumstances. So all the incriminating circumstances has to be put before the accused person. Now, the most vital evidence is PW3, and that has not been put to him in his 313. Which appears the appellate court has ignored while upholding the conviction under 325. Previous injury, lathi. I'll come back at 2. You think over because there are a couple of decisions in 3 as per 313 is concerned. So just have a look because this is not a case where foundation is there or something because sometimes that is also there or one question. You know, that can also be, but here the entire PW3's evidence is not placed. What will
I
be the
got-
effect?
And that question was not put to my defense, my lord. One question is usually put that what is your defense?
That is another
That
thing.
is also
But
not given to you. If you have anything to say, my lord.
are you carrying any authority? Why? It must be alarmed, armed with authorities.
His own is.
No problem. Yes, Mr. Kotokji?
GMC matter, my lord, actually, your lordship, heard. The style and appliances regarding the amendment amending 417 of GMC Act.
That is listed today.
Your lordship directed the standing council GMC to look into the matter whether there is evidence where it was construction was done
This is item 22.
22 and 20
Huh?
22 and 23, madam.
So has the GMC, who is appearing for GMC? Anyone is here?
One.
You want another date?
Anytime, your lordship heard the matter about. Very come on Tuesday, my lord. You can finish it off, my lord.
As prayed for by Mr. P. Kotoki, Learned Counsel for the petitioner, we list Tuesday.
Tuesday next, but I will inform him.
27, 22 and 23. Please inform. 22 and 23, right?
Yes, ma'am. Your lordship, that regarding whether the construction.
All right, on that day,
7, 8 floor, 9th floor was constructed prior to the amendment act.
I remembered. Do for further hearing quickly. Can you read the evidence of PW3 from the trial court records? No problem. Mr. Counsel, you take your seat. Sit. Yes. Yes, Lord Thakur. This is crucial. Read PW1. All right, all right. Continue. All right. Now 4. All right, 2. 2 PW2. Because 1 is the victim. Now this has to be corroborated, this part of our evidence, isn't it? 1 has been put to him. Now 2. You see? He has not, and she has not described. Lathi, head, these have not been. They have not. In cross also, I'm sure nothing has come. Okay, then 4. Hmm? See? All right, all right, all right. Correct. That is why I'm saying this only PW3, who's an independent witness, have said. And this has not been put to the accused in his 313 statement, explanation. isn't it? Yes, Mr. Counsel, do you have the file? Let's come. You can continue reading from, I think we have already read till 10. Come to 11, page 25. Yes, please read.
PW5 is the medical officer who examined the injured person. She has stated in her evidence that on examination of injured informant Draupadi Burman, she found the following injuries. A. Tenderness present on the left forearm, left arm and left cheek, and B. Fracture on the left ulnar bone as per X-ray report.
That was not Allah, it was Allah. There, the appellate court judgment said Allah. That's why I was wondering, what is Allah? Yes.
In her opinion, injury number 1 is simple and caused by blunt object, and injury number 2 is previous injury caused by blunt object. On the same day and at the same time, she also examined one Tutu Burman and found tenderness present on right hand of little finger. In her opinion, the said injury was simple in nature and caused by blunt object. Exhibit 3 is the injury report of the informant, and Exhibit 3
Counsel, your name?
points to
Sharma. B. Sharma.
Bishop.
Mr. Sharma, read a little loud.
Exhibit 3 is the injury report of the informant, and Exhibit 3(1) is her signature. Exhibit 4 is the injury report of Tutu Burman, and Exhibit 4(1) is her signature. In her cross-examination, she has stated that she has not mentioned in Exhibit 3 and Exhibit 4 that the injured person were examined on the police requisition, and that she had no personal knowledge regarding the injured person. She has further stated in her cross-examination that she has not mentioned time of examination and age of the injuries in Exhibit 3 and 4. Para 12. The PW6 is the IO who has stated in his testimony that on 12/9/2009, he was attached to North Bongaigaon BP. And on that day, the IC, after receiving a written SRR, entrusted him to investigate the case. Thereafter, recording entry in the diary, he went to the PO. Before going to the PO, he got the injured person medically examined. In the PO, he recorded the statement of the witnesses found there. On completion of the investigation, he submitted charge sheet under section 341, 325, 506, 34 of IPC against the accused person. Exhibit 2 is the charge sheet, and Exhibit 2(1) is his signature. Para 13. Exhibit 1 is the SRR. According to Exhibit 1, the occurrence took place 3 times. First time, the occurrence took place on the night of 9/9/2009 at 1:30 a.m. Second occurrence took place on 10/9/2009 at 10 a.m. on the public road, where the accused person were alleged to have assaulted the informant with bamboo lathi on public path, and as a result, she sustained injuries on her left hand and forehead. The third occurrence took place in the house of the informant at 6 p.m. where the accused persons were alleged to have assaulted the informant and her 7-year-old daughter. As a result, left hand of the informant was broken and sustained injury on head and forehead. Her daughter Tutu Burman sustained injuries on the finger.
Mr. Bora, you've come for the GMC matter? Yes. Yes.
Her daughter Tutu Burman sustained serious injury on the finger of the right hand. Evidence of the informant cum injured person marked as PW1 is totally silent regarding the occurrence took place on 10/9/2009 at 10 a.m. According to her evidence, the third occurrence took place in her house where the accused person assaulted her. As a result, her left hand was broken and her daughter sustained injury on her finger. Para 14. Evidence of PWs 2, 3, and 4 is silent regarding the first occurrence and second occurrence as per in Exhibit 1. However, PWs 3 and 4 have categorically stated in their evidence that at 6 p.m. the occurrence took place in the house of the informant. Evidence of PW2 also perhaps shows that an occurrence took place in the house of the informant at 6 p.m. It has been submitted by the learned lawyer appearing on behalf of the accused persons that discrepancies as regards time of occurrence has created doubt in the mind of the prudent person. It is evident that the accused person are the nearest relatives of the informant cum injured person. In such a situation, false evidence cannot be expected. Of course, there is a minor discrepancy in respect of the time of occurrence, and in my opinion, for such a discrepancy, a case cannot be thrown out rightly. 15. In the instant case PW2 to PW4 can be said independent eyewitnesses and they are star witnesses. Their evidence clearly shows that the occurrence took place in the house of the informant, PW3, who is the neighbor of both informant and the accused person, has clearly stated in his testimony that the accused person assaulted the informant with bamboo lathi after entering into her house. From the evidence of PW4, it can be presumed that the accused person commissioned the alleged occurrence. I find nothing to discard the evidence of PW2 to PW4. It is evident that the accused person are nearest relatives of the informant. Considering all aspects, I also find nothing to disbelieve the evidence of PW1. Para 16. Exhibit 4 is the injury report of one Miss Tutu Burman, who is at present no more. It shows that she sustained tenderness. There is no evidence on record in respect of section 506 of the IPC. PW2 to PW3 stated before the investigating officer that on 10/9/2019 at 10 a.m. on the road, the accused person assaulted the informant with lathi. There is dispute regarding the PO. Hence, the accused person are not fastened with the section either 447 or 448 of IPC. Para 17, where there is a cross case, court is to see who the aggressor was. Admittedly, there is a cross case brought by the accused side. In the cross case, PW3 and PW4 can be said independent witnesses, and their evidence is totally silent at what time the occurrence took place. PW2 of the cross case is the accused person of this case, and her evidence shows that the occurrence took place at 5 p.m. Her evidence is silenced where the occurrence of cross case took place. In this regard, her evidence is supported by her husband. PW4 of the cross case had not seen the occurrence. Upon perusal of CD, it appears that PW3 did not state before the police that he saw the occurrence. It is doubtful that PW3 saw the occurrence in view of the discussion made above. It is doubtful that the occurrence of the cross case took place on 10/9/2019 at 5 p.m. in the house of the informant. Exhibit 3 is the injury report, which shows the informant Smriti Draupadi Burman sustained fracture of left ulnar bone. PW5, Dr. M. Kalita is the medical officer who examined the informant and found the following injuries, namely A. Tenderness on left forearm, left arm, and left cheek, and B. Fracture on left.
All right, Mr. Sharma. So what are your, one is 313
Yes, my lord.
and
My lord,
anything else?
other is that, my lord, in this case, only one lathi was, my lord, seized. And two person cannot beat a person by one lathi. And that, my lord, assault lathi was not also produced, my lord, before the court, my lord. There is a judgment, my lord, I will face, my lord,
Lathi is not produced.
not produced, my lord.
Lathi is seized or not?
My lord, it's seized. The IO has stated in his chief and, my lord, cross
Not
that
produced will not make the prosecution case fatal.
there is a, my lord, judgment.
Did.
Keep us, my lord, is a
Number one, PW3 not put.
Yes.
In 313. Number two, Lathi. Exhibit
not exhibited, my lord.
not exhibited.
Yes, my lord. Only mentioned in, my lord, in the IO mentioned it in cross, my lord. These are the judgment, my lord. One judgment is, my lord. Pass away page, my lord, 12, my lord.
Hmm?
Page 12, my lord, of this. This is not, my lord, one bunch is,
But what is this one?
this one is, my lord, for in respect of, section 4 and 3 of the Probation of Offenders Act, my lord. And on that ground, my lord, release, my lord. In my case, my lord, neither the CJM nor the appellate, my lord, court considered under my lord probation of offender, sir. And not
That
three-
is a different thing. That is then,
And-
this court can consider, but,
360 also, my lord, of the CRPG is not, my lord, considered by the appellate court, my lord.
yes, which
My
one?
lord, at page, my lord,
Ipasaro,
Ipasaro, my lord,
Ipasaro.
at page 12, my lord. And para 38, 39, 40, and 42, my lord, is relevant.
Yes,
Para 38, my lord, may I read, my lord?
yes, please.
In the case of Muhammad Aman and
Ju-
another
just-
versus the
just one,
state of
Just,
Rajasthan,
just one, sir. 1-3, para,
para, my lord, 38, 38,
yes,
39,
yes,
40,
yes.
and 42, my lord. 38, my lord.
Yes, please read.
In the case of Muhammad Aman and another versus the state of Rajasthan, 1997, Criminal Law Journal SC 452, the apex court noticing that the seized articles, which could be the best evidence in the proof of the claim of the seizure, having not been produced and exhibited during the trial, was fatal to the prosecution case. In the instant case also, apart from non-production of the most important article, that is the dao or knife allegedly used by the accused appellant, coupled with the defense version that the injury were sustained by the victims from the sharp bamboo sticks, makes the prosecution weak. 39 minutes. In the case of Kallikat Kunhu versus the state of Kerala, reported in AR 2000 SC 1235, the eyewitness stated that the dagger was used to inflict injuries upon the deceased. However, the apex court found that if that be so, the dagger could not have been enclosed in a sheath. It should have been found unsheathed and ought to have some blood stain. Under those circumstances, the apex court held that the same strong probabilized the version put forward by the appellant that the incident did not take place in the manner narrated by the prosecution witnesses. It was observed by the apex court that if the dagger was not used to inflict injuries, there was no weapon of offense produced before the learned trial court. 40 minutes. In the instant case also, apart from the fact that the seized articles were not produced, most importantly, the weapon allegedly used by the accused appellant, it is also not the case of the prosecution that there were blood stains. All these factors have rendered the prosecution case highly improbable. As observed above, no amount of suspicion, howsoever strong it may be, can lead to any conviction. In the instant case also, there might be suspicion about the conduct of the accused appellant, but at the same time, having regard to the fact that there is inherent contradictions in the prosecution case, coupled with the fatal discrepancy of non-production of the seized articles, more importantly, the dao or knife allegedly used by the accused appellant has made the prosecution case weak. In such circumstances, it cannot be said that the offense allegedly committed by the accused appellant has been proved beyond all reasonable doubt. In para 42, for the foregoing reason and this, I have no hesitation to hold that the prosecution has failed to establish the case against the accused appellant beyond all reasonable doubt. Consequently, the accused appellant deserve acquittal. Next, my lord, next, Meenakshi Sundaram, next. Judgment is also related to my lord, same. Here also, my lord, para 4, 6, and 7, my lord, is related.
Yes.
Para 4, my lord. The learned counsel for the petitioner contended that it is a serious flaw of the side of the prosecution that when the alleged weapon has not been marked, it goes to the very root of the case. And in such circumstances, the petitioner accused 3 should not have been convicted. And in support of the contention, the learned counsel for the petitioner accused 3 has placed reliance upon unreported judgment of this court in criminal revision number 772 of the 2008 Raja versus State by Sub Inspector of Police Mahendra Mangalam Police Station, Dharampuri District. For better appreciation, it would be more useful to refer para number 6 and 7 of the said judgment, which reads as follows. Para 6. The main ground of attack raised by the learned counsel of the petitioner is that the non-production of the material object, namely crowbar, allegedly used by the accused in the commission of the offense, is fatal to the case of the prosecution. no doubt the courts below, even though pointed out that there is a slackness on the part of the investigation, especially in not producing the material object, the courts below have concurrently held that by itself will not be a ground to acquit the accused, as the witnesses have spoken in unison about the use of the material object during the commission of the offense. Further, the courts below have taken note of the evidence adduced by the doctor to conclude that the prosecution witnesses have sustained injury due to the use of crowbar. In this context, useful reference can be made to the decision of the court in the case of Sri Rangam versus Forest Range Officer Salem, 2005 Criminal Law Journal 987, whereas this court had an occasion to consider a case arising out of Tamil Nadu forest case. In that case, this court, by following the decision of the Honorable Supreme Court in Jitendra versus State of Madhya Pradesh, 2004, 1 Madras Law Weekly Criminal 433, 2003 Criminal Law Journal 4985, held that non-production of sandalwood and the ambassador car in which it was transported is fatal to the case of the prosecution. In that case, sandalwood was transported in an ambassador car and the quantum of the sandalwood log was estimated to be 196.5 kilogram. In that case, the properties seized were not produced during the course of the trial. However, at the time of remand of the accused on 29/3/1990. In the last part, my lord, this court having regard to the above facts held that,
Caesar have understood. Anything else?
yes, my lord.
What
And
are the other decisions?
Yes, my second decision. Other decision in respect of my lord. One, the first is my lord,
Delay.
the first one is my lord, they have to prove their case of FIR in the deposition of the, before the court. They have stated in the FIR something else and in the deposition else, my lord. Therefore, I am cited, my
That,
lord.
all that I'm not going.
And my lord, next, my lord, 3 and 4, my lord, is the improvement, my lord. Material statement made first time before the court is not accepted, my lord.
Which
Material improvement, my
Which one? Which one?
that, my lord, page 26, my lord. State of Rajasthan versus Rajendra Singh, my lord. That para, my lord, 7 and 8 is relevant, my. That
What
page-
is the improvement in your case?
My lord, the statement made before the court is the first time they have made, my lord. In their 161 statement, those statement was not, my lord.
Have you,
Yes, put to the IO, my lord.
have you put it in
Yes.
the IO?
IO and as well as to the, my lord, their witness also.
Yes.
Page 27, my lord, para, my lord, 7.
Yes.
It was submitted by the learned counsel for the state that as many as 6 witnesses were found injured and that would establish their presence at the place of incident. In our opinion, this contention is of no help to the appellant because their evidence has not been discarded on the ground that they were not
But
present.
Mr.
Their evidence,
Counsel, this is again, relating to the appreciation. This part, because the appellate court has reappreciated the evidence and has held them to be correct. Now, whether the revision court can go into that, see, 313, I'm with you. 313, I'm with you. As regards non-production of the lathi, I have my reservation because the rest of the things are proved. Mere non-production may not in all cases lead to see, yes, it will certainly weaken the case.
only thing that
Now,
the
this
injury-
third point that you're trying to say, FIR and all, these are all factual
Yes,
aspects.
ma'am, that is my lord.
These are factual aspects.
But my lord, somebody might have not stated the statement before the 161.
That is for the trial court. Ultimately, before at the court, they have said it. Now, whether omission, not, because you see, not stated is an omission. It's not contradiction. It is an omission. Now, because of that omission, whether that inference can be drawn, not drawn, would depend from facts to facts of cases. It cannot be a cardinal principle. Then an omission, therefore it's a contradiction.
minor omission is my lord okay, but my lord,
See,
it's of my
some-
major contradiction.
you have to understand at that time, because 161 is only the initial deposition. But yes, if something is said in 161, tomorrow before the court something else is said, which both cannot go together, then of course you can take the benefit
not
of
a
that
contradiction.
contradiction. But not omissions. There can be omissions sometimes. I think, Mr.
I-
Kotoki, there is, Mr. Kotoki, do you remember that case 58, I think? Huh? Uh-huh. Correct, Tashildar. 59, right? Yes, where I think this were have been clearly omission and Tashildar, give me my report. Tashildar Singh versus State of Punjab, AI 59. If you get it, you just give it. Thank you. Yes.
May I read my lord that judgment, my lord? True judgment for improvement.
See, I'm not saying that but you see, these are for the trial, at the trial court and the appellate court stage. Now this court, you have to understand that you are before a revision court.
Yes, ma'am.
I am with you as far as 313 is concerned. You understand what I'm saying?
Yes, yes.
Because by not putting 313 to the accused, a miscarriage of justice has been done. But now you cannot expect this court to go into all these evidences and find out whether there is a contradiction, omission. Both the courts have already looked into. There's a concurrent finding. Not, and the same again, whether perverse or not perverse. Definition of perverse, you know, when there's no evidence.
Yes.
Yes, you, anyway, I don't want to stop you. You show.
Only my lord, two para is here, man.
Which page?
Page my lord 27, para 7. 7 and 8.
Yes.
It was submitted by the learned counsel for the state that as many as 6 witnesses were found injured and they to establish their presence at the place of incident. In our opinion, this contention is of no help to the appellant because their evidence has not been discarded on the ground that they were not present. Their evidence was discarded because they were found not telling the truth before the court. It was also submitted by the learned counsel that the evidence of PW 1 to 4 stood corroborated by two independent witnesses, namely Ramjilal and Jivan Singh. PW 8 Ramjilal had stated that he had gone to the spot on hearing the sound by a gunshot and tried to snatch away the gun from the respondent. But he was contradicted by his police statement, wherein he has not stated anything regarding snatching of the gun. This omission on such a vital point has to be regarded as a contradiction, and it creates a serious doubt about the truthfulness of the version. PW 9 Jivan Singh had stated that he had also rushed to the spot on hearing the sound of a gunshot. He further stated that he had made an attempt to save Harveer and in doing so, he had received an injury. He had not so stated before the police. This shows that this witness had made a material improvement before the court in order to make his evidence acceptable. In next, my lord, next case also, my lord.
Yes.
Next case is in respect of omnibus statement, my lord. And no, not a single witness has stated that who assaulted my lord, because there is only one lucky and 2 person is there. Regarding omnibus, my lord, at page 30, para 4, my lord. Very small para, my lord. Yes, 30 para.
Yes.
It is to be noted that PW1 Gangadhar is the person who has lost the affair. He is the son of deceased Mathura Lal. He alleged that his father died because of the injury caused by Man Singh, who has given a blow on the head of the deceased. He specifically alleged that Man Singh has caused injury with Gandasa. on the head of the deceased from the sharp side. Further, PW4 Devlal is another eyewitness who had not specifically assigned any injury to any of the accused and has merely given an omnibus statement that all the accused have caused injury to the deceased by sickle, gandasa, lathis and spear. According to him, accused Monsing had a gandasa, accused Brahma, Pappu and Bansi had lathis and accused Mansaram was empty-handed. Injury by sickles and spear are not found on the body of the deceased. In such circumstances, the statement of Devlal, PW4 is also doubtful. And my lord, Rina Hazarika, in respect of Rina Hazarika, my lord, para 19 is my lord important, page 37.
Yes.
37, my lord, para 19, my lord. Section 313 CRPC cannot be seen simply as a part of OD Ultram Partem. It confers a
Para?
valuable right.
Para?
Page 37, para 19. Page 37,
This is Rina Hajur. This is on 313.
313, my lord. Honorable Apex Court, my lord, passed this judgment from our Honorable Guwahati High Court, my lord. Page 37, para 19.
Yes.
Para 19, my lord. Section 313 CRPC cannot be seen simply as a part of OD Ultram Partem. It confers a valuable right upon an accused to establish his innocence and can well be considered beyond a statutory right as a constitutional right to a fair trial under Article 21 of the Constitution, even if it is not to be considered as a piece of substantive evidence, not being on oath under Section 313(2) CRPC. The importance of this right has been considered time and again by this court, but it yet remains to be applied in practice as well shall seen presently in the discussion to follow. If the accused takes a defense after the prosecution evidence is closed under Section 311(1)(b) CRPC, the court is duty bound under Section 313(4) CRPC to consider the same. The mere use of the word may cannot be held to confer a discretionary power on the court to consider or not to consider such defense, since it constitutes a valuable right of an accused for access to justice and the likelihood of the prejudice that may be caused thereby. Whether the defense is acceptable or not, and whether it is compatible or incompatible with the evidence available is an entirely different matter. If there has been no consideration at all of the defense taken under Section 313 CRPC in the given facts of the case, the conviction may,
How is it helping you?
because my lord, that my lord, incriminating material.
Where is that decision? This is not on that. This is if the 313 explanation is not considered. This is on that. Your argument is that the incriminating circumstances have not been put. So if it is not put, then the entire case of the prosecution goes. Where is that decision? You have brought so many decisions, but your main star decision should have been that.
In my lord, 313, my lord, earlier I said, my lord, that question was not put. That
Correct,
do you have any defense?
Mr. Counsel, the decision that you need to show is to that effect. That when the incriminating circumstances is not put to the accused, in 313, the prosecution case fails. Where is that decision?
My lord,
You have not given that decision. This is subsequent. Here, incriminating circumstances have been put, and the accused have given explanations. But the trial court has not considered those explanations. This is what it is being said. Because you see, the reason of giving that opportunity is for the accused to give, because accused is not adducing evidence in the beginning. So accused has to be given an opportunity that here, 1, 2, 3, 4, these are the circumstances. And give him an opportunity to explain each of the circumstances. Suppose he explains. And then he adduces evidence also. These things has to be considered. Because the the standard of proof for the accused is not strict beyond reasonable doubt. He has to probabilize, isn't it? Now suppose that explanation, if that explanation creates a doubt, keeping in mind whatever other evidences are there, then of course it may be said that the accused could probabilize his defense. But there has to be some consideration. Now, if that consideration is not there, then the case will go. Correct. But that's not your case. You have to show. Let's take down this 2009 volume 4 SSC 769. A lot of decisions have been referred here. Paragraph 14. Paragraph 14 to paragraph 16. Then AI 1984 Supreme Court 1622. One 142, 144, and 198. These are two Supreme Court judgments only. Yes. रखा है। Can I get a print? What does it say? No, but about incriminating circumstances. What does it say? Please read that. এটা আনিব দিয়ক না। Yes, please read. Yes. Paragraph. But you are reading a D. Yes. Even what you are showing here also, this is on the earlier decision which you have shown. Any failure to consider the accused explanation of incriminating circumstance in a given case may vitiate the trial and endanger the conviction. That is okay. I am on, what about, because you see PW3 evidence has not been put in 313. Will that not vitiate the trial? So where is the question of him showing the prejudice? It is his valuable statutory constitutional right. You see, I will come to prejudice. Prejudice is suppose you give the gist and you have not given it properly. Then the question will come whether any prejudice has happened or not. Suppose you put everything together, then also. But here, that entire PW3's evidence has not been put to him in his 313. Where is the occasion for him to show that it has prejudiced? It has obviously prejudiced him. He has lost an opportunity to know that as regards the PW3's testimony, which clearly says that the PW3 have seen him assaulting the deceased, the victim with a lathi, and because of which she fell down, she got hurt in her head. This was not put to him. Where is the question for accused now to come and show before this board that this is how I've been prejudiced? Isn't this his constitutional right? Because this is not you see, this is not about odi alteram partem. This is not a question of giving him opportunity, natural justice and all that. That not giving of it, not issuing a notice, prejudice or not. This is not that. Hmm. Does it say that not your decision has to be on the point? Yes. Dum, dum. That is different. Motive not put. That will not vitiate. You see, everything cannot be put in 313. That is on the basis of the inferior that one party will argue. Now, can you put the arguments also now? In 313, are you required to put arguments? Huh? That is different. All right, you hear this 2009. I've given a copy to you, mister. You start reading from paragraph. I do not know if you have the same paragraph numbering. It starts from section 313 CRPC reads as follows. Could be in the initial paragraphs, paragraph 14 maybe. A lot of judgments have been quoted. From here you read.
Yes, one, para 10, section 313 CFC reads as follows.
Mr. Sharma, be attentive.
313 power to examine the accused. In every inquiry or trial for the purpose of enabling the accused personally to explain any circumstances appearing in the evidence against him, the court may at any stage without previously warning the accused put such questions to him as the court considers necessary. Shall, after the witnesses for the prosecution have been examined and before he is called on for his defense, question him generally on the case, provided that in a summon case where the court has dispensed with the personal attendance of the accused, it may also dispense with his examination under clause B. Number two, no oath shall be administered to the accused when he is examined under subsection 1. Number three, the accused shall not render himself liable to punishment by refusing to answer such questions or by giving false answers to them. Number four, the answers given by the accused may be taken into consideration in such inquiry or trial and put in evidence for or against him in any other inquiry into or trial for any other offense which such answer may tend to show he has committed. Para 11. The forerunner of the said provisions in the old code was section 343. Therein, it was worded thus 342. 1. For the purpose of enabling the accused to explain any circumstances appearing in the evidence against him, the court may, at any stage of any inquiry or trial, without previously warning the accused, put such questions to him as the court considers necessary, and shall, for the purpose aforesaid, question him generally on the case about the witnesses for the prosecution have been examined and before he is called on for his defense. Number two, the accused shall not render himself liable to punishment by refusing to answer such questions or by giving false answers to them. But the court and the jury, if any, may draw such inference from such refusal or answers as it thinks fit. Number three, the answers given by the accused may be taken into consideration in such inquiry or trial and put in evidence for or against him in any other inquiry into or trial for any other offenses which such answers may tend to show he has committed. Number four, no oath shall be administered to the accused when he is examined under subsection 1. Para 12.
All right, we'll continue at 2. Try and get hold of a copy of this. Yes. Let me first finish this. Well, let him finish.
My lord, para 12, my lord.
Yes.
Dealing with the position as the section remain in the original form under the old code. A 3-judge bench of this court in Hete Singh Bhagat Singh versus the state of Madhya Pradesh, AR 1953 SC 468 that the statement of the accused recorded by the committing magistrate and the session judge are intended in India to take the place of what in England and in America he would be free to state in his own way in the witness box. They have to be received in evidence and treated as evidence and be duly considered at the trial. 13. Parliament thereafter introduced section 342A in the old code, which corresponds to the section 315 of the present code, by which permission is given to an accused to offer himself to be examined as a witness if he so choose. 14. In Vibhuti Bhushan Das Gupta's case, Supra, another 3-judge bench dealing with the combined operation of section 342 and 342A of the old code made the following observation. Under section 342A, only the accused can give evidence in person and his leader's evidence cannot be treated as his. The answers of the accused under section 342 is intended to be substituted for the evidence which he can give as a witness under section 342A. The privilege and the duty of answering questions under section 342 cannot be delegated to a pleader. No doubt, the form of the summons show that the pleader may answer the charges against the accused, but in so answering the charges, he cannot do what only the accused can do personally. The pleader may permitted to represent the accused while the prosecution evidences is being taken. But at the close of the prosecution evidence, the accused must be questioned and his pleader cannot be examined in his place. The Law Commission in its 41st report considered the aforesaid decision and also various other points of view highlighted by legal men and then made the report after reaching the conclusion that the summons cases where the personal attendance of the accused has been dispensed with either under section 205 or under section 540A, the court should have a power to dispense with his examination. And in other cases, even where his personal attendance has been dispensed with, the accused should be examined personally. 16. The said recommendation has been followed up by Parliament, and section 313 of the code, as is presently worded, is the result of it. It would appear prima facie that the court has discretion to dispense with the physical presence of an accused during such questioning only in summons cases, and in all other cases, it is incumbent on the court to question the accused personally after closing prosecution with evidence. Nonetheless, the Law Commission was conscious that the rule may have to be relaxed eventually, particularly when there is improvement in literacy and legal aid facility in the country. This thinking can be discerned from the following suggestions made by the Law Commission in the same report. We have, after considering the various aspects of the matter as summoned above, come to the conclusion that section 342 should not be deleted. In our opinion, the stage has not yet come for it being removed from the statute book. With further increase in literacy and with better facility for legal aid, it may be possible to take that step in the future. 17. The position has to be considered in the present setup, particularly after the lapse of more than a quarter of a century, through which period revolutionary changes in the technology of communication and transmission have taken place, thanks to the advance of the computerization. There is marked improvement in the facilities for legal aid in the country during the preceding 25 years. Hence, a fresh look can be made now. We are mindful of the fact that the two judge bench in Usha K. Pillai, 1993, 3 SCC 208, has found that the examination when accused person can be dispensed with only in summons case. Their lordship was considered a case where the offense involved was section 363 IPC. The two judge bench held that a warrant case is defined as one relating to an offense punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. Since an offense under section 363 IPC is punishable with imprisonment for a term exceeding 2 years, it is warrant case and not a summons case. Therefore, even in cases where the court has dispensed with the personal attendance of the accused under section 2051 or section 317 of the court cannot dispense with the examination of the accused under clause B of section 313 of the code because such examination is mandatory. 18. Contextually, we cannot bypass the decision of three judge bench of this court in Shivaji Shahabrao Bobode versus the state of Maharashtra 1973 2 SCC 793, as the bench has widened the sweep of the provisions concerning examination of the accused after
Omission.
closing prosecution evidence.
Considering the fallout of omission. Yes, read it.
Contextually, we cannot bypass the
No,
decision.
no, read from the learned judges in that case.
Learned judges in that case were considering the fallout of the omission to put to the accused a question on a vital circumstance appearing against him in the prosecution evidence. The three judge bench made the following observation therein. It is right law, nevertheless fundamental that the petitioner's attention should be drawn to every inculpatory material so as to enable him to explain it. This is the basic fairness of a criminal trial, and failure in this area may gravely imperil the
validity of the trial itself.
itself if consequential miscarriage of justice has followed.
Yes.
However, where such an omission has occurred, it does not ipso facto vitiate the proceeding, and prejudice occasioned by such defect must be established by the accused.
Yes.
In the event of evidentiary material not being put to the accused the court must ordinarily exclude such material from consideration.
Consideration. Yes. And PW3 goes. Yes, read. You will get your opportunity.
It is also open to the appellate court to call upon the counsel for the accused to somewhat explain the accused as regards the circumstances established against him, but not put to him. And if the accused is unable to offer the appellate court any plausible or reasonable explanation of such circumstances, the court may assume that no accessible answer exists, and that even if the accused had been questioned at the proper time in the trial court, he would not have been able to furnish any good ground to get out of the circumstances on which the trial court had relied for his conviction. 19. The above approach shows that some dilution of the rigor of the provisions can be made even in the light of the contention raised by the accused that non-questioning him on a vital circumstances by the trial court has caused prejudice to him. The explanation offered by the counsel of the accused at the appellate stage was held to be a sufficient substitute for the answers given by the accused himself. Number 20. What is the object of examination of an accused under section 313 of the code? The section itself declares the object of the explicit language that it is for the purpose of enabling the accused personally to explain any circumstances appearing in the evidence against him. In Joy Devi Dev versus State of Punjab, year 1963 SC 612, Gajendra Kar J, as he then was, speaking for a three-judge bench, has focused on the ultimate test in determining whether the provisions has been fairly complied with. He observed that the ultimate test in determining whether or not the accused has been fairly examined under section 342 would be to inquire whether, having regard to all the questions put to him, he did get an opportunity to say what he wanted to say in respect of the prosecution case against him. If it appears that the examination of the accused person was defective and thereby a prejudice has been caused to him, that would not doubt be a serious infirmity.
This is exactly what appears to have been done in your case. Because the entire evidence of PW3 is not put. So if that is not put, then how can it be said that he has got a fair opportunity? Because that part is not given, but he saw specifically. PW3 saw assaulting and all. Because PW2 said scuffle. PW4 said lying and running. 3 specifically. Suppose 2 and 4 would have said the same thing. Then of course there was no prejudice because you would have explained the same thing. Unless of course you would have said that no, PW3 was not there, but that would not change anything. Isn't it? You understanding, Mr. Sharma, what I am saying? You keep listening to me carefully. You will get your chances to react. So the purpose of continuing this dialogue with you both is to give you an idea what is going on and to respond appropriately at the appropriate time. Because PW2, PW3, PW4, 3 said different things. And it is only PW3 who specifically said it. And there is no evidence of anyone that which out of which petitioner has assaulted. That is also not there. Isn't it? If you considered all that together, and then the lathi was not examined, there is lacunas from the prosecution side. I'm not only on one. Now, if that be so, then how can this court ignore these lacuna? Because ultimately, maybe it's a revision jurisdiction, but nonetheless, these lacunae are there, it appears that patently erroneous on the face of the record, material palpable error has caused, isn't it? Continue.
Thus, it is well settled that the provisions is mainly intended to benefit the accused and as its corollary to benefit the court in reaching the final conclusion. 22. At the same time, it should be borne in mind that the provision is not intended to nail him to any position, but to comply with the most salutary principle of natural justice enshrined in the maxim odi ultim partem. The word may in clause A of subsection 1 in section 313 of the code indicates without any doubt that even if the court does not put any question under that clause, the accused cannot raise any grievance for it. But if the court fails to put the needed question under clause B of the subsection, it would result in a handicap to the accused, and he can legitimately claim that no evidence without affording him the opportunity to explain can be used against him. It is now well settled that the circumstances about which the accused was not asked to explain cannot be used against him.
Yes. Why you did not? This is decision which you should have cited.
Yes, my lord. Now, my lord, I search my lord one recent judgment of
Where we
2025.
go all that later. Continue.
Para 23. But the situation to be considered now is whether with the revolutionary change in technology of communication and transmission and the marked improvement in facilities for legal aid in the country, it is necessary that in all
Is it
cases,
necessary?
the accused
Is it necessary? Not,
is not necessary,
is it necessary? Read.
is the requirement and would be general rule. However, if remaining present involves undue hardship and large expense, would the court not elevate the difficulties if the court hold the view that the situation in which he made such a plea is genuine? Should the court say that he has no escape, but he must undergo all the tribulations and hardship and answer such questions personally, presenting himself in court? If there are other accused in the same case and the court has already completed their questioning, should they too wait for long without their case reaching finality or without registering further progress of their trial?
Wait,
until-
this part is not required. Now you come to 16. 16,
My para is are different.
the second last paragraph. It is to be noted.
It is to be noted that in the instant case, there was no reference to any of the incriminating materials. If the foundation of the prosecution case was the LS confession before the custom authority, that material was not brought to the notice of the accused person. Above being the position, there is no infirmity in the impugned judgment to warrant interference. The appeal is this
Now this was an appeal against
against my lord.
acquittal. Acquittal.
Yes.
That acquittal was not interfered because 313 in 313 confession was not put. And then 54, where is 54? 84, sorry. On 42, apart from the aforesaid comments, there is one vital defect in some of the circumstances mentioned above and relied upon by the High Court, so and so, as these circumstances were not put to the appellant in his statement under section 313 of CRPC, they must be completely excluded from consideration because the appellant did not have any chance to explain them. This has been consistently held by this court as far back as 1953, where in the case of so-and-so, 1953 Supreme Court 468, this court held that any circumstance in respect of which an accused was not examined under section 342 of CRPC cannot be used against him. ever since this decision, there is a catena of authorities of this court uniformly taking the view that unless the circumstance appearing against an accused is put to him in his examination under so and so or section 313 of so and so, the same cannot be used against him in Shamu Balu versus so and so. If held as under in this case of 79, in the first place, he stated that on the personal search of the appellant, chadi was found, which was bloodstained. And according to the report of the serologist, it contained human blood. Unfortunately, however, as this circumstances was not put to the accused in his statement under section 342, the prosecution cannot be permitted to rely on this statement in order to convict the appellant. So this is a consistent view. You see, prejudice comes later. But if it is entirely not put, then how can he show that it has been? Obviously, it will be prejudicing him because he absolutely didn't get a chance to explain that so and so witness have seen him assaulting, have seen him assaulting her with the such and such weapon at such and such place. These things have not been put to him, and nobody have said all this except PW3. And 144, it is not necessary for us to multiply authorities on this point, as this question now stands concluded by several decisions of this court. In this view of the matter, the circumstances which were not put to the appellant in his examination under 313 have to be completely excluded from consideration. If there is anything which is which distinguishes these authorities and which has widened the scope or something, then you give. Yes, that I have seen. Which one? '13. 2013 cited by? You have cited this? Sorry. Yes, yes. Gyan Chan. Yes. Yes, yes. Mr. Sharma, right? Huh?
Sarkar.
Sarkar. Sorry. Sarkar, take your seat. Counsel, a decision is contextual. So therefore, the decision has to be understood in what context it has been rendered. The context is in para 3 and 4. See, because here in the facts of this case, it appears that the incriminating statements were put. It is not that it was not put. It was put. But you are faced with a situation where that entire incriminating, that only vital incriminating circumstance was not put. That is where you are faced with. And three judges bench, those decisions that, the decision which I had pointed out is also a three judges bench. And has clearly said confession not put. Because why? Because that judgment is based on that confession. You see, if it would have been a case where there were certain other things, and the judgment is in that situation, the confession, even if you exclude it, the rest of the circumstances are sufficient, then of course, only the confession will be taken out, not the entire trial, isn't it? But here, the basic is in that PW3, because victim has said, no doubt, but corroboration. Correct. Very vital irregularity, material irregularity. Oh, no, of course. We are still all trying. Well, both ways, it's dangerous. You cannot let an innocent be convicted at the same time. No guilty should go scot-free. Hmm? No, and it was one lathi she claims. Both cannot have the lathi. Died. And the lathi is not offense was
325, punished for 6 months.
what is this? Oh, this is that a Tashildar case. Right, let's try. 25, no? Heard, Mr.
N, sir.
L.
N.
N. Sarkar. Your name is not here.
Yes. Ma'am. N, sir.
So in the
Yes,
20,
20.
20. I was thinking 25. 20, huh? Heard Mr. N. Sarkar, learned counsel for the petitioner. Stop. Also heard Mr. B. Sharma, learned KPP for the state respondent. This petition is filed under section 397 of the CRPC 1973, read with section 401 and section 482 of CRPC, seeking quashing, seeking setting aside and quashing of the judgment and order dated 27/2011, passed by the learned Chief Judicial Magistrate Bongaigaon, hereinafter referred to as the trial court, in GR case number 491 stroke 2009, whereby the petitioners accused were convicted under section 341, 325, 34 of IPC and sentenced to undergo simple imprisonment for 1 month under section 341 IPC and simple imprisonment of 1 year and a fine of rupees 500 under section 325 of IPC. In default, simple imprisonment for 1 month. And the impugned judgment and order dated 30/8/2012, passed by the learned Additional Session Judge FTC Bongaigaon, hereinafter referred to as the Appellate Court, in Criminal Appeal number 25 within bracket 3 stroke 2011, whereby the Appellate Court partly modified the judgment passed by the trial court by acquitting the petitioners accused under section 341 of IPC and sentencing and the sentence of imprisonment is reduced to 6 months instead of 1 year under section 325 of IPC by maintaining the fine. So, correct. It is submitted at the bar that not submitted at the bar. Mr. Sarkar submits at the outset that a petitioner accused number 1, Sarothi Bala Barman, during the pendency of the petition expired on 23/12/2024 and accordingly produces a copy of the death certificate issued by the Government of Assam, Department of Health and Family Welfare, which is kept on record and marked as X. X. In view of the aforesaid submission, is it required to mention that no. The brief facts of the case is that is that on 9/9/2009 at 1:30 AM, Rameshwar is the accused. One Rameshwar knocked the door of the informant, and since she refused to open the door, he left her house by saying that he would take revenge for the same. On the following, it is the further case of the prosecution that on the following morning, since the informant apprised the villagers about the same, the accused persons attacked her on village path and assaulted her with lathi, for which she sustained serious injury on her forehead. It is the further case of the prosecution that again at 6 p.m. the accused persons entered into her house and assaulted her and her minor daughter with a lathi, as a result of which her wrist of left hand was broken and she sustained injuries on head and forehead, and her daughter sustained injury on finger of right hand. Accordingly, on 12/9/2009, the informant lodged a FIR before the jurisdictional police station, which was registered as Bongaigaon PS What is the number?
Bongaigaon PS case number 363, public 2009.
Where will I get it?
FIR is at page minor.
All right, you tell Bongaigaon police.
Police station case number 363,
Yes, case number 363
public 2009,
oblique 2009.
that section.
Under section
341,
341, 447, 325, 506 IPC. Thereafter, the investigating officer completed the investigation and submitted charge sheet under section 341, 325, 506, 34 IPC against the accused petitioners. The trial court framed charges under section 341, 325, 506, IPC against both the petitioner, accused person, and stop. During trial, the prosecution side examined as many as 6 prosecution witnesses, including the medical officer and investigating officer, whereas the accused petitioner have been examined under section 313 CRPC, wherein the defense wherein the plea of defense was total denial. Stop. No defense witness was adduced. The trial court, after closure of evidence and hearing the parties, was pleased to was pleased to hold the petitioners accused guilty under section 341, 325, 34 IPC and accordingly convicted thereon. Aggrieved by such conviction, the petitioners accused filed appeal before the before the appellate court, and the appellate court, though acquitted the petitioner accused from section, acquitted is section 341. 341, however, modified, however, while maintaining the conviction under section 325 IPC, modified the sentence of imprisonment from 1 year to 6 months. Situated thus, the present revision petition has been filed. Mr. So Sarkar, learned counsel for the petitioner, submits that the trial court ought not have convicted the petitioners in the absence of reliable evidence to the effect that the investigating agency has not seized and produced the assaulted Lathi before the trial court, and as such, the conviction and sentence passed is illegal and is erroneous in law. In support of the aforesaid submission, he relies upon the decision of the apex court. No, one is Supreme Court Madras, one is Madras High Court.
No, my lord, this is our high court, because, my lord.
The one following decisions, huh? Don't say applicable, following decision. Number one, Kipasero versus State of Arunachal Pradesh, reported in 2005, 4 GLT 86. Number two, Meenakshi Sundaram versus State so-and-so, reported in 2017, volume SSE Madras 30175. Also the other one, na, that Rajasthan,
These two.
only two, na?
Sorry, my lord, that next one also, my lord, Meenakshi Sundaram.
I have already said.
Yes.
He further submits that the evidence of PW3, based on which the trial court has convicted the petitioners accused, is not put to the accused while he was, accused persons while they were examined under section 313 CRPC, and therefore the trial stands vitiated, and hence the decision, hence the judgment and order of the trial court as well as the appellate court is palpably and manifestly erroneous on the face of, is erroneous, full stop. In support of the aforesaid submission, he relies upon the decision of the apex court. In the case of Reena Hazarika versus State of Assam, reported in 2019, volume 13 SSE 289. He further submits that the that that the material witnesses have improved their version of the prosecution story since that of the initial statement made before the investigating officer under section 161 CRPC, comma, such statements, such depositions also vitiates the trial. Hence, reliance in support of the aforesaid submission, he relies upon the decision of the apex court in the case of State of Rajasthan versus Rajendra Singh, reported in 2009, volume 11, SSC 106. What is that Madhya Pradesh case?
Madhya Pradesh case. I don't,
That is also improvement.
I don't see the state omnibus statement was made, my lord. In our case also no specific allegation.
Okay. He further submits that none of the prosecution witnesses have deposed before the court as regards out of the who have claimed to witness the incident as regards out of the two accused person, which one has dealt the lathi blow on the forehead of the of the informant. He accordingly submits that there being no specific allegation against the accused person, the conviction based on such
Omnibus.
omnibus statement ought not ought to be interfered by this court while exercising revisional jurisdiction. That's all.
And my lord.
Huh?
4 and 3 of the Probation or Offenders Act.
That is relevant because for contra, Mr. B. Sharma, learned APP, submits that mere not putting the evidence of PW3 before the accused persons while they were examined under section 313 CRPC shall not vitiate the trial unless and until the accused petitioners shows as how the same has caused prejudice to them. He relies upon the decision of the apex court in the case of Dhyanchand and others versus State of Haryana, reported in 2013, volume 14, SSC at page 420. That's all. I have given my prudent considerations to the arguments advanced by the learned counsels appearing for the contending parties and have perused the materials available on record. I have also considered the case laws cited at the bar. It appears that PW1, who is the informant, lodged an FIR on 12/9/2009 stating inter alia that on 10/9/2009 at 5 p.m. the accused persons along with other 4 came to her courtyard and abused his wife. The informant is the wife or husband.
The husband might.
So PW1 is not the PW1 is the wife. Is
But there is a cross case, I mean, maybe that cross.
yeah. Say the informant lodged himself, came to his house and abused his wife, PW1, and pelted stones at the roof of his house.
See, the my application in cross case filed by my husband.
Is it? Which is the FIR in your case?
FIR is at stage my lot 17 man.
Sorry, please delete that part. The brief, I'm sorry. It appears that on 11/9/2009, PW, the victim stroke PW1 lodged an FIR stating inter alia that on 9/9/2009 at 1:05 a.m., the accused petitioner number 1 called her to open her door. But since she did not open the door, the accused persons later on returned back to since she did not open the door, the accused persons returned to their home after warning her that they will take revenge. It is further alleged that on 10/9/2009 at about 10 a.m., the accused number 2 attacked her and wounded her left hand and forehead by a stick as he was furious for disclosing by a stick. Stop. PW1. It appears that PW1 during trial deposed that reports that one Rameshwar on the night before the occurrence came to her house and called her to open the door. But since she did not open the door, he told her that he would take revenge. It further appears that PW1 further deposed that on the next day at about 4 o'clock, two accused persons entered into her house and assaulted her. As a result of which her hand was broken and they also assaulted her 7-year-old daughter, as a result of which her finger was broken. During cross-examination, PW1 clarified that the accused persons also brought a case against her and the same is being tried, and that she was assaulted with wooden lathi. It appears that PW2, who is a co-villager, deposed that hearing shouting, he came to the place of occurrence where he found that there was a scuffle going on in the house of PW1. It appears that PW3, who is PW3 co-villager, who is another co-villager, deposed that hearing shouting, he came to the place of occurrence and found the accused person entering in the house of the PW1 and assaulting her with bamboo lathi, as a result of which her hand was broken It further appears that PW4, who is another co-villager, deposed that hearing halla, he came to the place of occurrence and found the informant lying on the ground and the accused person running towards their house. It appears that PW5, who is the medical officer, examined PW1 and her daughter. And on examination of PW1, she found the following injuries. Page 25, A to B. Okay. PW6, who is the investigating officer, it appears that PW6, who is the investigating officer, deposed in his testimony that what are these contradictions which you took it out from the IO? Where do I find it? Because,
In the evidence, my lord,
do you have an English version?
Assamese.
Read. It appears. We've already said that. First, you say who deposed that after he received the FIR, he after receiving FIR, he investigated the case and examined the victim as well as other witnesses, and accordingly submitted charge sheet. Yes, please read.
In PW3 and all, সেই যুগল বৰ্মন মই গুচৰীয়া আৰু পদকীয় দৰক চিনি পাওঁ। ঘটনা তাৰিখে আজিৰ পৰা 2 বছৰমান আগত সন্ধিয়া
You are reading. You're reading whose evidence?
PW3, my lord.
No, but have you asked these questions to the IO?
I know, yes.
Please tell me that.
I, my lord, the PW3's question of PW3 এ মোৰ আগত কৈছিল যে ঘটনা ৰাতিপুৱা 10 বজাত হৈছিল। PW3 এ মোৰ আগত কোৱা নাই যে পদকীয় দয়ে কুচৰীয়াৰ ঘৰত আৰু কুচৰীয়াজনক হাৰ ভাঙে।
That is only that much. Where is the 161 statement? Is it there? That is PW3, all right. It appears that during cross-examination of PW6, he clarified that PW3 did not state before him during 161 during examination during his examination under section 161 CRPC that the accused persons had
not entered house
entered
পদকীয় কুচৰীয়াৰ ঘৰত আৰু কুচৰীয়াৰ হাত ভাঙে।
had entered the house of the PW1 and broken her hand. That's all right. Then thereafter,
PW4 এ মোৰ আগত কোৱা নাই যে তেওঁ দেখা পায় যে কুচৰীয়াজনে মাটিত বাগৰি পৰি আছে।
he further clarified that PW4 has not stated during interrogation under section 161 CRPC that he had seen the victim PW1 lying on the floor and the accused persons running from there, from the place of occurrence. Yes, that's all. That also goes. And PW2 talks about scuffle. PW2 doesn't mention the scuffle is between the accused and the. It's a case of no evidence. If you remove PW3, but then PW3 now appears to be also doubtful. Initially did not say. Okay. It further appears that after the closure of the prosecution evidences, the accused persons were examined under section 313 CRPC. A close perusal of the question answers, a close perusal of the 313 examination statement of the accused persons indicates that no question as regards PW as regards the deposition of PW3 was put to the petitioners. it appears that it is PW3 who has specifically stated, deposed that the accused persons assaulted the PW1 by entering into her house. That apart, the other prosecution witnesses, PW2, PW4, does not has not seen the assault. That being so, the testimony that the deposition of PW3 being one of the crucial incriminating circumstance ought to have been put to the accused persons during the 313 examination, and the same having not been put, serious prejudice has been caused to the petitioners, for which the trial gets vitiated. Reference in this regard is made to the decision of the apex court in the case of Sharad Virichan Sarda versus State of Maharashtra, reported in AIR 1984 Supreme Court 1622. Wherein the apex court has held that unless the incriminating circumstance is put to the accused person in his examination under section 342 or section 313 of CRPC, the same cannot be used against him. Relevant paragraphs of the aforesaid judgment and order of the aforesaid judgment of the apex court is reproduced hereunder for ready reference, quote unquote, paragraph 142, 143, 144. Reference is also made to the decision of the apex court in the case of Inspector of Customs so-and-so versus Yashpal, reported in 2009, volume 4 SSC at page 769. Paragraph 14 to 16. 14 to 16. It's reproduced here under for a reference, quote unquote. Reading of the aforesaid judgments, it appears that reading of the aforesaid judgment, it appears that the foundation of the prosecution case being the alleged confession made by the accused before the customs authorities, having not been brought to the notice of the accused persons during his examination, during their examination under section 313 CRPC, the trial stands vitiated. Why are you standing up? The decision of the apex court in the case of Gyanchand Supra relied by the Mr. B. Sharma led APP to buttress before this court that unless and until prejudice is shown by the accused person, non-putting of an incriminating circumstance during his 313 examination cannot vitiate the trial, is not acceptable in the facts and circumstances of the present case. As stated above, it is the evidence of PW3 alone on the basis of which the impugned conviction was rendered by the trial court and affirmed by the appellate court, which admittedly was not put to the accused persons during 313 examination. That being so, the accused persons were kept completely at dark and did not get opportunity to explain the aforesaid material circumstance available against them. Hence, there is serious, hence it cannot be, hence it can be safely concluded that the accused petitioners did not get a fair opportunity to opportunity in the trial. Hence, the evidence of PW3 cannot be looked into. If the evidence of PW3 is taken away, the case rests upon the evidence of PW1, the victim herself, and PW2 and PW4. It appears that PW1 has improved her version than that of the FIR, and has also not indicated in her deposition before the trial court as regards who out of the two accused persons has dealt the lathi blow. It further appears that though she has mentioned that she was assaulted in her forehead is mentioned, na? Don't say that. That apart, PW, oh no, sorry, huh? One second. Involvement is which one? Which decision? Involvement? Rajendra Singh. Reference is made to the decision of the apex court in the case of state of Rajasthan versus Rajendra Singh Supra. Paragraphs have been observed. which is reproduced here under for any use. Quote unquote paragraph 7. Involvement, you had given another decision. Oh, not that, huh? You say reference is made to paragraph 4 and 5 of the decision of the apex court in the case of state of Madhya Pradesh versus Papi, reported in Supra, huh? Quote unquote 4 and 5. It appears that it appears that in the event, no, in the present case, the PW1 has not specifically assigned any injury to any of the accused and has merely given an omnibus statement that the accused persons have assaulted her. In such circumstances, the statement of PW1 victim appears to be doubtful. That apart, PW2 and PW4, though has not seen the assault, however, during trial has deposed that deposed the presence of the accused persons. However, the same was not disclosed at the time before the police while they were interrogated under section, not interrogated, while their statement was recorded under section 161 CRPC. Such omission on such a vital point certainly contradicts their testimony before the trial court, and it creates a serious doubt about the truthfulness of their versions. Reference is made to the decision of the apex court in the case of state of Rajasthan versus Rajendra Singh Supra. Paragraph 7 of the aforesaid judgment is quoted, reproduced here under for the reference quote. This brings me to the next argument of Mr. S. Sarkar, learned counsel for the petitioner, to the effect that the lathi, the alleged weapon with which the assault was alleged to have been caused, has been, it was seized, no?
That was seized.
Which was, though was seized, but the same was not produced before the trial court. Stop. It appears that the lathi, within quotes, being the material, being a material, being the weapon with which the alleged assault, with which the assault has been alleged to have been caused, is a material evidence, and the same being not produced and exhibited during the trial weakens the case of the prosecution. reference is made to paragraph 39, 38, 39, 40, 42 of the decision of the coordinate bench of this court in the case of Ipa Cero Supra, quote unquote. Reference is also made to the decision of the Ipa Cero is division bench of no, single bench, and the Madras one is
Single bench.
Madras also single.
Single bench.
Coordinate bench of the Madras High Court in the case of Meenakshi Sundaram Supra. Paragraph 4, 6, and 7 is so and so. It appears that the trial court as well as the trial court has convicted the accused persons under section 325 IPC based on such evidence. Paragraph Paragraph 15. Seventeen, 18 is reproduced here in the following. Paragraph 12, 13, 14, 15, 16, 17, 18 of the appellate court judgment in order is also reproduced here in the following. Did I give you the pages? Trial court, I've given you page 26 in the trial. It starts from there. And appellate court, it starts from which paragraph did I say? Paragraph page 33. Okay. Reading of the aforesaid paragraph, aforesaid finding of the trial court as well as the appellate court, it appears that the conviction is based on the basis of the testimony of PW3, which was not put before the accused persons during their examination under section 313 CRPC, and therefore the same cannot be, and therefore the judgment and order of both the trial court as well as the appellate court is palpably and manifestly erroneous. That being so, the appeal succeeds. So and so judgment stands set aside and quashed. Were you in jail?
Oh my. There.
And any bail bonds?
There gone.
Bail bonds since discharged. Anything else to be added? return case records. Huh?
Additional session does FTC. Provide
For
for my.
Huh?
Record is to be kept in the.
no, that's return. The registry knows what is to be done. Anything else to add, Mr. Gautakar, Mr. Sharma? Only the bail bond. No? Oh, sorry. Thank you. I stand corrected. Don't say approbation. Decision, and some decisions are here. This much, right? Some of the decisions are in. Yes, Mr. Lal.
It is done. Lots of conviction under 279, 304A and 427 is done. Maximum punishment of 2 years, 6 months, and fine of 1,000 was imposed. In default of fine, simple imprisonment for 2 months.
304A.
304A, rash and negligent driving.
Hmm?
Rash and negligent driving.
Rational negligence. Yes.
Our contention is this, if we take the whole evidence at face value, Milord, ingredient of rash and negligent driving is not made out. Second is that there is no evidence that is the identity of the accused or the identity of the truckman. And the third is that once the statement, Milord, the spectrum of rash and negligent driving was not put together. These are the three contentions. The very only 5 witnesses were examined. The investigating officer was not examined. Including the doctor, it was 6. The defense did not adduce any evidence. After examination in chief and cross-examination, he was convicted. Appeal preferred, appeal dismissed, and accepted before your lordship. If your lordship, we have supplied a paper book in the matter. Lordship may kindly.
Paper book is there.
We have.
Paper book person.
I'm more than.
Yes.
Page 1 is the FIR. Just only 5 witnesses.
Mr. Lal, this is a revision petition.
Lordship, just
I will come to the evidence if need be,
Yes,
but
Lordship.
first show me the judgment. Let us see what is the error, and then we will go to the evidence. Straight away, I don't think it would be
Yes.
correct for a revisional court to go to the.
No.
Yes, you want to say something? Huh? Take your seat. Yes,
The judgment starts from page 16 of the appeal.
page
Page 16 of the appeal.
16.
The first page basically describes what we have stated now. FIR was lost. The accused pleaded not guilty, and after examination of chain and arguments were heard.
This is under challenge.
This is understood. Point for determination. It's page 17.
You can avoid all that. Let's come to
Decision and discussion thereof is page 17.
page.
Page 17, 117.
Very short judgment.
Very short.
Yes,
very-
read from page
There are 7.
7.
Before appreciation of the evidence of the prosecution side, I'd like to highlight the prime contention of the prosecution side. In the instant case in hand, the case of the prosecution is that on so and so, and son of maternal uncle of the informant so and so was coming to the private so and so was Bhopal through bicycle at that point of time. One truck number so and so was coming from the Wesley and Nagli, dashed him in front of Bhopal Girls High School and caused that. So it appears the prosecution tried to prove the fact that the driver of so and so knocked the brother of the informant in front of the school, Wesley and Nagli, and caused that. We have to look what the witness, what the of the prosecution had deposed before the court. I perused the position PW1 carefully, where I found that PW1 only heard about the incident and seen one man fallen down on the left side of the road. He heard the truck dash the statement. He has not seen the accident. PW2 in his deposition stated in the year 2009, so and so was coming through his cycle from the eastern side to the western side at 9:30 a.m. At that time, one truck came from Tezpur side and dashed him in Kolkata. Later on, he went to the police station. People told him that truck dashed so and so from the wrong side. So it appears that PW2 also heard about it. Now let us have a look at what the other witnesses have deposed for the court. PW3 in a deposition stated the son of his maternal uncle named so and so was coming to take stuff. At that point of one truck coming from the opposite from Gopur knocked him and caused death. He came to Gopur police station. Police was examining because he did not know the accident. He did not know how the accident happened. He did not know which was the truck and driver. He filed the Ajahar as per the direction of the police. So it appears that PWC has also not seen the accident and heard about the accident. PW4 in his report stated that so and so Minister Vipul Bora conducted a meeting at Gopal district. Permissible was came to cycle from the eastern to the west, and from the opposite side, one truck from the opposite from Peaceful, one truck came and dashed so and so and caused death. He heard about that. When he came to the place of the incident, he came to know that that truck came from the wrong side and dashed so and so. So it appears that PW4 also heard about the incident and he came to place the incident after the accident occurred. So all the four are the
All right, five.
hearsay witness. Five.
Five.
He is the only eyewitness in the matter. Now let us have a look what PW5 deposed before the court. PW5 in its deposition stated that on so and so 8:30 a.m. over the national highway near Gopur Girls High School, accident took place. One truck came from Vishnu Charali and knocked one man on the side of the road. Said person was coming from cycle from Kolaguri to the on the eastern side towards Gopur to roadside. Said truck tried to overtake another truck and knocked the man. Said person died on the spot. Cycle was damaged. Was standing nearby. He had seen the accident and truck was fled away. He came to know that the said truck was nabbed. He came to know lot. Police came and seized the cycle. Said man was coming from one meeting. In his cross-examination, he deposed that from his house to the place of incident is 2 furlong away. He was standing near Tini Ali and near that accident took place. He does not know the truck number and driver. He knows the man whose accident took place from the same side. Two trucks were going, and due to overtake, accident took place. From the deposition of PW5, clearly appears before the court that PW5 is an eyewitness of the case, and he saw the whole incident. In this case, it appears before the court that except PW5, none of the witnesses have seen the but the deposition of all other witnesses supported the contention of PW5.
Your form is Das, no? Your form? Any private correspondent?
No, no. At that point, we are not supposed to inform.
Now it is required.
In the middle, it was required. Now again, it has been without.
Yes.
In this case, it appears before the court that except PW5, none of the witnesses have seen the incident, but the deposition of all other witnesses supported the contention of PW. If we carefully gone through the deposition of all the witnesses, and one common thing appears from the deposition that one truck came from Tezpur side near the Gopur Girls High School, dash so and so who was coming from Kalabari towards Gopur through cycle. In this case, I find PW5 is an eyewitness of the whole case who has seen the whole incident by standing nearby. From the deposition PW5, it clearly appeared before the court that two trucks were coming from Tezpur side and one truck tried to take another truck and knock the deceased person on the wrong side and cause that. The said fact was also supported by all other witnesses who have heard about the incident, report of the doctors. PwC also shows that it was caused because of so and so, which suggests shock and now we have two facts and one. One is the only PW5 stated that he tried it. One truck tried to overtake another truck. The investigating officer was not examined. PW5 in his cross-examination has admitted, taken option to that he did not state for the police that he stated that one truck tried to overtake another truck. This was the first statement made by PW5 before the court. And as such, in my humble submission, will inadmissible evidence. Second, all the witness lordship has said none has identified that truck. None has identified that driver. Admittedly, even if we take the whole PW5 statement at face value, two trucks were there. Was might be offending vehicle. MBI report was not agreed. Investigating officer was not, Milord, examined by the court. In such circumstances, how the court established my identity? My truck was involved in the accident.
Because your truck was napped immediately, it was driven by.
Not immediate. It take a lordship to that. And that can be disposed only by the investigating officer. That evidence is never before the court. So the court only has to presume.
So your case is of no evidence.
No evidence, and more importantly, lordship can see statement under 313. No question of rash and negligent driving was put to me. Even if we take the evidence at face value, cutting that so far as overtaking part, then also rash and negligent driving will not come in.
But that is not required to be put. If the gist of PWs have been put, that is enough. That is an argument. Arguments are not put in 313.
No, no. Rash and
The
negligent
ingredients of the section is not required to
not
be also
required,
put.
but has to say that you drove the truck rashly or negligently.
You know, that you
Just
see.
because you are driving that truck,
Mr. Lal,
that's it.
what can be put in 313 is what has come in evidence.
Sir.
On the basis of those evidence, what inferences will be drawn cannot be put in 313.
Hmm.
Correct?
Sir.
Now, what PW5 has seen has been put? Yes or no?
Yes.
Then what more to be put?
Sir.
The inferences to be drawn
Yes,
from the
I agree with you, lordship, on that.
that is not going to be put in 313. So that point,
That you
I don't think will take you any.
Only thing is that if that statement by PW5, he never made this statement before the
Let
police.
us see the appellate code and then we'll go to the evidence.
Appellate could also be on the same use as. Lordship, may kindly see para 13, page 19. How they connected the evidence without. Why the trial could conduct.
Page?
Page 19, paragraph 13.
Yes, I've seen that.
Yes, only.
I have
only
highlighted
yes,
it.
All the witnesses silent about the.
Lal, I've highlighted it.
Thoughts.
Appellate code.
Only factor that also be how I'm connected, then it can directly come to. From paragraph 17, page 22.
Hmm?
Page 22, judgment starts from page 20.
Yes, yes.
And page 22 onwards.
Yes.
Page 23. Paragraph 17. Last part.
Yes.
It appears from the order dated 23/3/2012, passing GR case number so and so by the first class, that the examination of the investigating officer was dispensed with, as he could not be produced despite several summons issued to him. The court, after delving deep into the matter, is of the opinion that non-examination of the investigating officer should not come in the way of the prosecution had otherwise been able to prove the case beyond all reasonable doubt. From the case diary as well as the documents submitted by the investigating officer, while charge sheeting the accused seems to be enough to establish the case of the prosecution. Although the
I will not examine.
I am not exact. In this case, he was the most important witness to prove my arrest or the seizure of the truck. Although the investigating officer was not examined, the same will not definitely pose as a hurdle for the prosecution case for the reason that the IO would have parroted the content of the case diary as well as the documents submitted by him which were examined. In other words, the investigating officer would not have gone beyond his case diary as well as the documents submitted by him would not have made any difference to the prosecution case. As such, the case will not fall for non-examination of the investigating officer, as the prosecution has been able to substantiate the case due to hard as well as circumstantial evidence adduced by it. The prosecution case got blasted when it was proved that the driver that the accused had driven the vehicle. No evidence without. The truck bearing number so and so, when the accident occurred, so and so. This fact has been substantiated by the serial list number so and so, from where it is evident that the accused was driving the aforesaid vehicle when the accident occurred, having his driving license bearing number so and so, which was valid up to so and so. As such, there was no appreciation or doubt regarding apprehension or doubt regarding the involvement of the truck in the accident, which was driven by the accused at the time of the accident, which caused the death of Mr. Sabe. Another factor for which the prosecution case got a slot in the arm is the fact that the accused fled away from the place of the occurrence. Just after the accident, later on apprehended by the police personnel or local peers. This attitude of fleeing from the scene speaks volumes from the involvement of the accused. Now, this spectrum of exponents also Miller is not there in any evidence, any of them. So, in view of the above foregoing situation, I will with what the trial court.
Yes. Paper book. So it appears that the finding of the appellate court that accused was clearly driving the vehicle is not established. None of the PW witnesses have seen. Now
Not
it is
PW.
presumed that because he was arrested, but who has proved that part?
No one. Not even
Achha, I'll just come in 2 minutes. Just 2 minutes.
my basic submission is that the identity has totally been not been established. The IO has not been examined who could have proved my arrest or who could have proved the seizure of the vehicle lot, from where it was seized, how it was. The only seizure witness of the truck was PW5. If the lordship now may pick up the evidence of PW5 for him, it's page 22 of my paper book.
Yes.
Page 22. document.
Yes.
Around 9:30 a.m. on 24/11/2005, this is a translated version. The accident took place in front of Gopur Balika High School on the National Highway at Gopur. One truck coming from Bayatarali side knocked on a person at the edge of the road who was coming from the opposite direction on a bicycle. The said man was coming from Kolabari towards the east side of the Gopur on his bicycle, while the truck was overtaking another truck. It knocked on the man. The man
One
died
second now. One truck.
Yes.
Please read again. One truck.
while the truck was overtaking
So
another
one
truck,
truck coming from Beach Hariali.
which had knocked down a person at the edge of the road.
No, side, Beach Hariali side knocked down a person. Yes. So continue.
Who was coming from the opposite direction on a bicycle. The straight man was coming from Kalabari toward east side of Gopur on the bicycle. While the truck was overtaking another truck, it knocked down the man. The man died on the spot. Cycle was damaged. I was standing nearby. I saw the accident and the truck fled away after causing the accident. It says when the truck fled away after causing the accident. I know that he is a resident of so and so. Other men informed the police station. Police came. Police seized the bicycle involved in the accident and seized the notice of the meeting by exhibit number so and so is my signature. Police were coming from the same meeting. People were
Police
coming from the
came,
same.
police seized the bicycle, the notice of the vehicle. I know, yes.
I do not remember the date of the SMS calendar on the day of the accident. I have signed the seizure list at the place of occurrence. I have
But
signed
this Caesar list is about the bicycle.
about the bicycle, and if lordship takes up MR 42 about the truck also.
He is also a Caesar witness to the
let me-
truck.
Yes, no.
Acha, that will come later.
MR 17 of the,
Will come. Now read.
I do not remember the SMS calendar on the day of the accident. I have signed the seizure list at the place of the, I have signed the seizure list at the place of the occurrence. That is important. That my residence is about 2 furlong away from the place of occurrence. I was standing at by Tinali. The accident took place near it. There is a school in the northern side, 10 feet away from the Tinali. I do not know the number of the truck. I do not know the truck driver. I do not know the name of the person who died in the accident. When police arrived at there, I came to know that the person was of so and so. The accident took place at National Highway. Two trucks were coming from the same direction and caused the due to overtaking. The police examined me at the place of occurrence. I did not tell the police that I was near the place of occurrence at the time of death. I also did not tell the police that the accident had taken place while the said truck was overtaking another truck.
But where has he, in his evidence, where does he say that the police seized the truck and he has signed that?
So that is not there, but he has signed
No, that is, then it is not exhibited.
Yes, Milord, because other document, other thing was there. If your lordship takes up MI 52 minutes in the record, Milord,
Mhm.
page number 17 record,
Page number,
lower court record.
trial court record.
Record.
Trial court record should be only. Give it to Mr. Lal. Please Pick it out. No, Mr. Lal, what I'm trying to ask you is, you see, Caesar,
Yes, Milord, he has not stated that truck was seized.
yes, it has to be
Yes, correct.
exhibited, correct?
Correct.
Now, that seizure of the truck and the bicycle has not been done apparently from the same place.
Correct.
Because here he says he have seen, he have specifically said,
Cycle will be there.
police came, police seized the bicycle involved in the accident and seized the notice of the meeting by exhibit 3.
Correct.
Exhibit 1 is my signature. So and so.
Correct.
Where have we said about the truck?
That is not.
And
But
any, apart from him, anybody else have said?
no,
Then? Now what
but
you
the
refer,
seizure list, if your lordship says that
Yes.
truck is there.
yes, what is there in the seizure list?
I will take the.
Is that because, can the court look into the seizure list? It is not exhibited, it is not proved. So who has proved them?
It was exhibit, no, it was exhibit 3.
No, but who exhibited? Exhibit 3 is the exhibit by PW5. But PW5 says exhibit 3 is the bicycle seized and the notice of the meeting.
The truck number is.
You can read the vernacular deposition of PW5 if it's available in the trial court.
Yes.
record.
In the. There also, the paperwork also given, like,
All right. Is it there?
page 24 is there. I've given him the
Page
page 24 of the
20?
Court.
Yes. Read it slow. Can you? Hey, to look for more. That's little louder. মানে কি? The OP, Gompao, he comes to know. Just read that police आया. Where is the truck?
MR, what is the lordship says there is a
And carry on, you read the cross part. He has not said anything. This does, I'm yet to hear you, but we've already seen the evidences, right? Now, the basis of the conviction is that the accused was driving the truck and rash and negligent, and therefore, here is the evidence number one that the accused was driving. Number two, that the truck which the accused was driving was the truck in question. Where are these evidence? PW5 does not identify the truck. He does not see the truck. He doesn't say that the seized truck is the offending truck. Has he said that? Then who have said all this? Isn't it the duty of the prosecution to establish all this beyond reasonable doubt? So many gaps. Who is going to explain? Investigating officer has not been examined. How can you say that the seizure has been proved then? And even assuming seizure is proved, where is the evidence that so and so is the driver of that offending truck? Admittedly, there were two trucks involved. Which is the other truck? And how, on what basis one have assumed that this is the truck which has, is there any evidence showing that this truck was coming from this side?
MBR report was not.
Where are all this? And rash and negligent? What is there to show rash and negligent? MBI report not there. Whether brake applied, not applied. Nothing. We don't know anything. Mr. Kotogi, since you are sitting in the court and I take the opportunity of clarifying another aspect. The Caesar list, if the IO is not examined and he does not exhibit, that will not be, he has to prove it. Otherwise, how can that be? Just here it appears that the trial court has presumed that because this truck driven by the accused was seized by the IO, therefore it is him. How will it come? Who has said all this? Nothing not. And Mr. Lal fairly pointed out from the Caesar list that in that same Caesar list, which is Exhibit 3, apparently the truck is also mentioned. And PW5 has witnessed. But during examination, PW5, that person, he says bicycle. Police came, seized bicycle, and some notice of meeting is Exhibit 3, which I have signed. He doesn't talk anything about the truck. What was it doing? Thank you. Anything? What's come? Have they seen that? Have they seen the incident? Your trial court itself has discarded them, that they are not the eyewitnesses. The trial court has only taken PW5. So, where does it take you? All right, take your seat. Heard Mr. A. Lal, learned counsel, A. Lal, right? Learned counsel for the petitioner, stop. Also heard MS P. Das, N. Das, learned APP for the state respondent. That Caesar list is, Ms. Das, can you please flag mark that Caesar list in this? This criminal revision petition is filed against it is filed under section 397-401, read with section 482 of the CRPC 1973. Whereby seeking quashing of the order of conviction and sentence dated 18/4/2012 passed against the accused petitioners by the Judicial Magistrate First Class Viswanath Chariali, hereinafter referred to as the trial court, in GR case number 628/2012, registered under sections 279, 427, 304A of IPC. And whereby the petitioner was convicted under section 27, convicted and sentenced to undergo rigorous imprisonment for 2 years under section 304 capital A, rigorous imprisonment for 6 months under section 279 IPC, and a payment of fine of rupees 1,000 under section 427 IPC, and in default to suffer simple imprisonment for another 2 months. And the judgment and order dated 26/9/2012, passed by the learned Additional Session Judge FTC Viswanath Chariali, hereinafter referred to as the Appellate Court, in Criminal Appeal number 22 within bracket S-2 of 2012, upholding the judgment of conviction and sentence passed by the learned Judicial Magistrate First Class in GR case number 622 of 2005. The brief facts of the case is that on 24/11/2005, an FIR was lodged alleging inter alia that on 24/11/2005, around 9:30 AM, the informant's maternal uncle's son, one Padmeshwar Tabu, while was coming on his bicycle, was hit by a truck bearing number AS01K 5357 Gopur. Not 57. Being driven by the driver in rash and reckless manner. Being which was driven rash and recklessly. Accordingly, a case was registered, and after investigation was completed, charge sheet was submitted, whereafter the trial court frame charges under section 279-427-304 capital A IPC. And comments the trial. During trial, the prosecution adduced 6 prosecution witnesses and exhibited don't say exhibited, whereas defense, you had,
Not again.
whereas the defense apart from, whereas the accused was examined under section 313. No, whereas the incriminating materials were put to the accused persons in his examination under 313 CRPC, which he generally denied and chose not to adduce any evidence. Stop. Based on the thereafter, the trial court convicted the petitioner accused and sentenced thereunder, which was challenged in appeal by the petitioner accused, and the appellate court was pleased to dismiss the same. Situated thus, the present criminal revision petition has been filed. Mr. Lal, learned counsel for the petitioner, submits that the judgment and order of the trial court as well as the appellate court is manifestly erroneous in law, inasmuch as there is no evidence whatsoever based on which the conviction could have stood the eye of law. Per contra, MS Das, learned APP, submits that it is apparent from the evidence of the eyewitnesses that the petitioner accused is guilty of the offenses, and hence the conviction rendered by the trial court, which is affirmed by the appellate court, ought not be disturbed by this court while exercising powers of the third court. Correct? Stop. I have heard the submissions of the I don't think there will be further. I have given my prudent considerations to the arguments made by the learned counsels appearing for the contending party and have perused the materials available on record. It appears that the trial court has found, the trial court has held that PW1, PW2, PW3, and PW4 has not seen the occurrence, but has merely but are mere hearsay witnesses. Paragraph 7, 8, 9, 10 of the judgment and order of the trial court is reproduced hereunder for any reference. Quote unquote. Page 17. It further appears that the trial court, after looking into the evidence, testimony of PW5, has come to the finding that it is PW5 who has seen the whole accident by standing nearby, and that it clearly appears from the evidence of PW5 that two trucks were coming from the Tejpur side and one truck tried to overtake another truck and knocked the deceased person on the wrong side and caused death of the said person. It appears that in the light of the aforesaid deposition of PW5, the trial court held the petitioner accused guilty of the offense alleged and passed sentence thereof. It further appears that the appellate court, as well as after apt at this stage to refer to the testimony of PW5, which is reproduced hereunder for ready reference. A compilation of us at page 22, quote unquote, be divided. Huh? It appears that PW5 deposed that he saw one of the truck he saw that while the truck was overtaking, one of them knocked down the deceased. And the truck thereafter fled away. It appears that PW5 witnessed the seizure of the bicycle involved in the accident and also the seizure of the notice of the meeting by Exhibit 3. It further appears that during cross-examination, he clarified that he had signed the seizure list at the place of occurrence. It further appears that he further clarified that he did not know the number of the truck, nor did he know the truck driver. And that only after the police arrived there, he came to know that the person was of Gopur Nigam. It further appears that PW5 has not stated before the police during his statement during his examination under section 161 CRPC that he was standing near the place of occurrence at the time of accident and that the accident had taken place while the said truck was overtaking another truck. It further appears that he further clarified that he had not seen the seized articles in the court. Thus what is abundantly clear from the perusal of the testimony of PW5, on the basis of which the trial court has hold the petitioner guilty. Has not identified the truck which had alleged to have hit the deceased person. He has further not identified the accused petitioner as the driver of the said truck. It is absolutely clear that the evidence of PW5 cannot be taken as sufficient to connect the accused petitioner to be the driver of the offending vehicle. That apart, it appears that the investigating officer has not been examined as a witness. In fact, the seizure of the truck in question appears to have not been exhibited before this court by any of the witnesses. Though it appears that PW5 is one of the seizure witness in Exhibit 3 which also contains, which also list the offending, list the truck, the truck in question as a listed seizure, as a listed seizure item. Did not say a word as regards the seizure of the truck. In fact, he had clearly stated that the truck fled away from the place of occurrence, and it appears that he had clarified during cross-examination that he had signed the seizure list at the place of occurrence. There being absolute no evidence to connect the petitioner accused to the charged offense, the verdict of the trial court as well as the appellate court appears to be, trial court appears to be palpably and manifestly erroneous. This takes me to the judgment and order of the appellate court. Apt to reproduce paragraph 17 to 20, 21. Page 22. Reading of the appellate court judgment, it appears that the appellate court has held that there is no doubt regarding the involvement of the truck in the accident, which was driven by the accused at the time of accident, which caused the death of the deceased. Such finding of the appellate court is based on no evidence and therefore is totally perverse. In view of the above, this court has no hesitate. This court is of the unhesitant view that the judgment and order of the trial court as well as the appellate court is manifestly and palpably erroneous and perverse, and therefore is liable to be interfered with. Accordingly, the judgment and order is so and so of trial court, so and so of appellate court stands hereby is set aside and quashed. Anything else to be done? Return case records?
Now, this record has been sent by Milord with the copy of the order.
Return. That's all, nothing else? Bail bonds or anything?
I'm already on bail, Milord.
So anything to be said?
Yes, sir. The bail will also be discharged after 6 months. Milord.
Bail bond, it has already been discharged.
No, Milord. I have submitted this bail, Milord. I
Bail-
don't remember it, Milord.
All right.
Doesn't that matter?
Bail bond accordingly stands discharged. That's all, no? Time.
I'm okay.
24. Anyone there in 24? 24, time did a fixed corridor for next date. That appears to be. Then,
Number 25.
anyone there? 25? That appears time. 28, none appears.
Time.
29, 30th April. Then 30th April.
Abhinav, in this case, what paper book is there? I am appearing for private respondent because this appeal has been preferred by the victim against acquitted.
Acha.
So I am appearing for private respondent. And in the record below, there is a paper book. May I get one copy of
Item 29.
29?
Your name?
S. Sahu.
Mr. S. Sahul, learned counsel appearing for the respondent submits that though paper book has been submitted is available in the court's file. However, the same has not been furnished to him. Let registry furnish a copy of the paper book to Mr. S. Sahul, learned counsel for the respondent.
One more prayer, Miller. Respondent number 2 has expired on 13/3/20.
He further submits that during the pendency of the appeal, respondent number 2 has in the meantime expired on
13/3/20. 13th of March
13/3/2024.
2024.
Relist after
On 30. Public.
non appears date 31.
32.
Petitioner. Man appears with the petitioner. Yes, when mark her appearance. MS Das. M Das is present for R2 and MS same N. And Das the APP of the state are present. Huh? Relist on such and such.